Call to order the City of Bloomington Board of Zoning Appeals for September 22nd, 2022. Roll call, please.
Here.
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 Okay, we have the approval of minutes from June 23rd, 2022. Do I have a motion? Any comments or corrections? Okay, can we have a vote, please?
Aye. Or yay. Aye.
Yes.
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 Yes. Okay. Reports, resolutions, and communications.
Good evening. I'm Jackie Scanlon, Development Services Manager. We have a pretty full agenda tonight. We wanted to highlight that the Adobe compilation of the packet put the petitions out of order. So you will need to search for the case number to get to the beginning of the petition, or when they're about to start, I have written down which page number they're on in the packet, so we can just briefly let you know. So the first petition tonight, per the agenda, is V2722, and that starts on page 83. And that's all we have. Thank you.
Okay, thank you. We did have a question.
Yes, this is to staff. I know that, it's my understanding that I think City Council had instituted an out time for meetings so that they didn't run really, into the early morning hours. Is that true?
They set that for themselves. Your rules and procedures also set for you that you can't hear a new petition past 8:30 p.m. and that you can't go past 9 p.m. The rules also let you suspend any rule you want to suspend. So depending on where we are, as if we are still here as those times approach, then you all would discuss what you would prefer as far as having a hard stop or going over.
Okay, I thank you for that. I just want to make that clear on the front end because we'll discuss at the time, but I just want to make sure it was clear. Thank you.
And Jackie, you will alert us to when we're at that time. Okay, wonderful, thank you. Okay, so the petitions to be continued to October 20th, 2022 is AA-17-22, Joe Kemp Construction, LLC, and Blackwell Construction, Inc. This evening on our docket, we have the following petitions. V-27-22, Cutters Kirkwood 123, LLC. V-28-22, Warren Witt, Chipotle. AA-31-22, Lamar Advertising Company. V-32-22, Richard Judd. V-34-22, Adam Jackson, Caritas, Indiana, LLC. AA-35-22, Chris Bamba. V-38-22, Ryan Rental Incorporated and First National Realty Partners. V-39-22, Strouser Construction Company Incorporated, and V-41-22, City of Bloomington Redevelopment Commission, Cornerstone. Okay, so we are ready to, this is a case that was continued from our previous hearing. Can you advise us as how to handle time because the petitioner had no time remaining?
Sure. First, go ahead.
And I wasn't here.
Oh, and you weren't here, so.
Eric, I wasn't here for the last.
Okay, so please let the notes recognize that Eric is going to be recusing himself from this case, and he will join us afterwards. Thank you, Eric. Thanks.
I'm sorry, what page does it begin on?
It begins on page 83, packet page
Thank you.
83. Okay, so yes, this petition was heard last time. Mr. Rooker can correct me where I'm wrong, but I believe because the petitioner used his time and we also did public comment and closed it, that to open either of those, either more information from the petitioner or more information from the public, the board would have to vote to do that.
Have to vote to suspend the rules. Any vote on that in the affirmative would have to be unanimous in order to suspend the rules per the board's rules.
Okay, so the first thing we have to do is suspend our rules in order to allow additional comment and information as provided by the petitioner?
Correct, and it would be advisable, just a suggestion here, but as your rules set a time limit for presentations, you might also contemplate a particular time limit if you were going to do that.
Okay, thank you. Is there a recommendation from staff as to the time limit?
When discussing, decided to recommend somewhere between 5 and 10 minutes. The petitioner has already had the full amount allotted of the time that someone gets to present and extinguish that time. So yeah, we think 5 to 10 minutes would be appropriate.
Okay, and we don't have to have any review or summary of the staff report?
I don't think so. We had one thing we wanted to add, and otherwise, I don't believe, per the report, that Ms. Passos received anything else from the petitioner, so I assume he's planning to present some here.
Okay, okay. So I'm back to the board for a time limit. First of all, we have to
No,
vote to suspend our,
I'll move to suspend for extension of a hearing on case B-27-22 with a time limit from the petitioner of 10 minutes.
okay? I second it. Okay. Can we have a vote, please? Okay.
Yes.
Yes. Yes.
Yes?
Okay. So we are now to the petitioner. If you could please state your name, and then I will swear you in, and then you have up to 10 minutes to allow any additional findings that you may have that would be relevant to the case.
Kirkwood 1, 2, 3, the petitioner.
Thank you.
Hello?
Could you identify yourself again, please?
I am Randy Lloyd with Clear Path, also Cutters Kirkwood 1, 2, 3, the petitioner.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. You have up to 10 minutes to state your case.
As a point of order, I mean, this seems like Jackie has just pulled 10 minutes out of your hat. I mean, do I get an opinion as to what I was going to present, or is that your stand? I know this is kind of new, maybe new territory, but...
So I think that we are able to add additional time if
Okay.
we feel that
I
that's
just-
necessary.
Yeah.
Thank
All right,
you.
we could do that. And Jackie, can I... If I could... yeah, I'm sorry. That's okay.
You're fine, you're good. This one right here? Okay. I will project it, and then I will have your
yeah.
timer going here, so you can see my phone over here. And I'll tell you when you've got like 2 minutes left.
Okay. And then I just wanted to go to, if you'll go to page, yeah, just, let me see that one. Go down a little further. All right, that is not, if you'll keep that one, that is not the one I want, but.
Sorry, different file?
It is.
Okay, that's okay.
That one should be the, that's not the same one. What I wanted to ask, if we could kind of, if you recall, we had the two variances. One was for the 50% ground floor, and the other was for the windows. And I wanted to see if we could maybe bifurcate those, and let me talk quickly just about the additional 50 or the 70% window, and then I'll come back to the 50% on the floor. Is that fair enough?
You can organize your time however you'd like.
All right, well, first I'd like to, if I could, on the 70% first floor facade windows, we were initially talking last time about just the nature of the building, and what I wanted to just point out specifically about this particular one, because we had not made a decision on this one yet either, is that we are somewhere between 51 and 55%. I demonstrated to you what I measured on our block as far as what currently is just all in our block and how we comply. And I think what we came down to was that we were okay with, on the standard review, with the first two, but the strict applications will result in practical difficulties. And what I wanted to point out was, and Jackie, if you'll go to the other one, the other file, and right, one more there, the elevation. So this is sort of what you see on the elevations. And what I wanted to point out was that, and we kind of alluded to this last time, was what's unique about, particularly as the windows relates, is both the design, which has been driven by both the grade and our site location. And so as Ryan had mentioned before, is you've got on one end here, which is next to the CVS, we're at, I believe, 763, and then over here we're at almost 767 on the book corner. And so we're kind of cantilevering down. When you combine that with the fact that we have much significantly higher first floor ceilings to make the grades work, we're left with really tall sections of glass. And this is one of those I've determined in just practically going out and measuring everything, is that depending on where you pick the point to measure, it kind of changes the percentages. I think we actually do more than enough to sort of achieve the goals and objectives of the UDO, which is having the transparent glass, even with 51 to 55%. What makes this challenging, what Ryan pointed out last time, was like, for example, the last piece of glass here is over 11 feet tall. And the other glasses are either almost 10 feet or thereabouts. And Jack, if you scroll through, I mean, you can see, like, that's a window, I think that's a window 5. Go one more. And another one. Another one, sorry, one more. You'll go to the glass sections. These are just ones that so these are actually the glass sections that Ryan has put in. If you go to the next page, you'll see sort of like the sections of some of those that include that. And I don't know if you can see those, but we get really tall windows. And so physically, because of the way the grades work, the front facade of this has a tremendous amount of windows in it and is very transparent. And even though we don't hit that 70% objective, I think this more than accomplishes what we're trying to achieve as it relates to the UDO goals and requirements. I don't know, I mean, I participated as well. I don't know where the 70% came from, but I'd hazard to guess that there's hardly few buildings that are historical that we're trying to work our way into the neighborhood that are even close to 70%. So I would ask that you grant this variance just based on, one, the practical difficulties of the peculiar nature of the site and the way that the elevations work, and that we're actually, I just don't think we'll ever achieve enough windows based on this design where we're gonna end up with absurd height for glass just to achieve that, or we have to eliminate all the brick. And a lot of that brick design was driven before by the whole planning process. We needed to have things where we were breaking up the facades, and it just, again, I think it's a nice looking facade and it achieves that, and we really just can't get much taller glass in there and still achieve a 70%. And I'll leave it at that since I've only got like 10 minutes, so 5 minutes left. So I'm going to stop there on that one. Okay? Any questions related to that one? No? Okay. Then, Jack, if you'll go back to the other document. First, yeah, go back up, variance. Right there. So the ground floor area is kind of probably where this is the deal killer for us. This is the section that was, again, as I mentioned, was previously approved, and we had long discussions about what was it that was driving this. And what I wanted to point out was that, and I mentioned it at the previous hearing, was that there was this notion that somehow economic impact could not be considered, or that our business model couldn't be considered, or that economic injury by strict compliance couldn't be considered, and that is just not the case. The Indiana Court of Appeals has held since 1985 that this standard of review for practical difficulties does include economic impacts to the petitioner as well. And Jack, if you'll scroll down again. And what the Indiana Court of Appeals has held since '85 is that the BZA can consider on what are practical difficulties, you must consider the following standards: whether significant economic injury will result if the ordinance is enforced, whether the injury is self-created, and whether there are feasible alternatives. Additionally, the court has held that comprehensive plans and other documents can be considered by the BZA when you're considering these variances. And in a nutshell, significant economic injury will occur to this project and to us as petitioners without having the parking. Jackie, if you'll go to, it's another file. Oh, okay. Yeah, well, let's see here. Yeah, if you go to that BZA review standard. And then we'll come back to this document. So, and this is just I want to do just a quick overview. I know you're aware of the purpose of the UDO, but you know, when we look at the purpose of the UDO and we promote this, what it lists as what we're trying to do with a comprehensive plan and the UDO and how they're supposed to work together. And then if you'll scroll down a little further, Jackie, there, then this is the case, the Metropolitan Board of Zoning Appeals from McDonald's Corp. In '85, which really is the first time the Court of Appeals considered sort of what are practical difficulties, because I think that's when the state legislature had changed sort of some of these requirements. But this is kind of where it talks about that that significant economic injury from the enforcement of the zoning should be considered, and it lays out these standards. And this case law has been cited numerous times by the Indiana Court of Appeals up until most recently again in 2021. Interestingly, if you scroll down a little more, Jackie, this Glendale one petition was one where they were actually requiring them to have more parking. They didn't want to have the additional parking, and they really note that we have articulated several factors considered determining whether compliance, and this is where they lay that out, and they cite the case. And if you go that, will you scroll down again, Jackie? I'm sorry. All right. Well, nonetheless, because I'm really limited here on time, my point is the Indiana Court of Appeals gives you the discretion to make determinations and consider economic impacts in whether or not my variance should be granted or not. And so I think before it was just the opposite. I even believe that staff has been advised that you couldn't consider economic arguments, and I'd like to think that you can. And we've invested already, in addition to the land, over $500,000 in plans and reports and studies, and the fact that we cannot sell condominiums without parking spaces. I've got a letter from Brian Thompson, local broker that would support that notion that these need to have parking spaces. Additionally, part of what we're getting here is an incentive to place parking behind. The other peculiar difficulty here is that if I have to do the 50% requirement, because of the grade changes and the elevations that we have, we can't even feasibly, we can't get parking behind the building because you can't access it. And so I end up with a lot of waste or dead space. So I could go on, and perhaps if you would grant me another 5 minutes to wrap up this piece of it, maybe it'll make a little more sense.
I'm back to the board then.
I'll move for an additional 5 minutes.
Do you have a second?
Seconded.
Okay. Do we have to vote on that then? Okay. Can I have a vote, please?
It'll have to be unanimous again.
Yes.
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 Yep.
Okay, you have another.
Thank you very much, and thank you, Jackie. And then if you go back to my, all right. Yeah, so if you go, right, go back up.
That's for variance two.
Oh, that's variance two. All right, go to all right. So let's go to, next one. All right, so let's go down one more. All right, one more. Okay, so I would ask, and maybe your legal counsel could provide more input into this during if you have questions or answers related to that. But there is a lot of case law from the Indiana Court of Appeals on you having the discretion to consider economic impacts. And it doesn't matter that I have an acceptable use. Parking is permitted. And just because I have selected a use that has this difficulty doesn't mean that I have to pick another use to make it work. I mean, the truth of the matter is we could argue about every variance that we should pick if we wouldn't be here with variances if we didn't have things that didn't work out with sites. And to me, the argument that, well, then maybe it's not the best location or whatever, if it's a permissible use and we've designed it as such and we're seeking variances, those are parts of the things that we work out as a community. And we're trying to make these types of work. Otherwise, we would have a strict compliance that said whoever brought anything that didn't work for a setback or anything else, well, we would just say, go back and design it, or maybe you picked the wrong site. But those are not the practical answers that we want. We're trying to help people make things work in the community and work with our plans. And something as comprehensive as our UDO, we find these inconsistencies, and that's why we have these variances. And so what I'd like to say related to is that you have the discretion to consider it, and I would ask that you do consider the economic impacts. The other, though, is then the strict application of the terms that will result in practical difficulties is really just the peculiarities of this site, which are really, as I said, location, location, location. We're in a very tight urban site. It's probably one of the very few undeveloped sites in the Courthouse Square overlay. And so it's unique from that perspective. As I mentioned, we have approved uses, parking is permitted, but we've got this tight urban site that's bounded by 2 alleys and a historic building. So we get limited on what we can do, how we access things, and candidly, how commercial space or anything else works. As I mentioned, the UDO gives us incentives to provide parking behind our commercial space. With the 50% rule, I can't get parking behind there anyway. I just can't get the grades to work. So if you look at, Jackie, can you go back to the plans? Mm-hmm. All right, and go So if you look at sort of these kinds of elevations, so you can see kind of how we drop, but if you go up the alley, you're at, like I said, 766, and we go up, the next floor elevation is sort of 781. So if you were looking at the top of the alley, I think it's like 774. And so these grades just make it really difficult to find an access point. We can't find access points anywhere else around the alley to get into that back part of that space if we're doing 50%, unless we're doing this long shotgun all the way back the building and then accessing it off of Kirkwood, which is what we're trying to, accessing it actually, sorry, next to the CVS building and Kirkwood, which is what we're trying to use as the alley to come in. And so where you see the kind of the vent area is kind of where as what we're proposing is where the garage access would be. Previously, coming in, when the original 9-0 vote on the coming in off of Washington, we were coming in through the loading zone. And that loading zone, I do not own. I had an initial agreement. The building is condoed. So CVS has, and it's actually a gentleman from New York owns the CVS space, and that loading zone runs with them. So I don't own that. I thought at the point I had access to it, and then that went away. So coming up the alley, though, has the same issues. It's got the grade issues. You just can't get into the back of the building. So if we can go back to the other document. So the grades and the cost prevent any other reasonable option to make it work to get any parking behind it. So I'm left with all this dead space that I can't do anything with. And besides have more commercial space. And having more commercial space in this market is like suicide. I wouldn't want to own more commercial space. I've got what I can handle even with this project. And if you'll just go, Jackie, real quick. I have 9 seconds. One more document. Will you pull up both the commercial space and the multifamily? Pull up both of those, will you? And then the multifamily too. Scroll that one down. I just want to point out real quickly, these are current comps. So total, if you scroll down, Jackie. So you can see on this one, this is current like commercial space, and it includes everywhere in Bloomington. But we've currently got on the market, 2 minutes to wrap, just to show you this piece.
We'd have to extend. Do I have a motion to extend? No. Okay, I think we understand where you're
Okay.
going with them. Thank you.
There's a lot of commercial space available.
Thank you.
All right.
Thank you. Okay, so we are now back to the board for questions, discussion.
I've just got a couple, if I can start. These are for staff. In the packet, just want to make sure I state this correctly. The petitioner has not proposed any changes or new information. The petition remains as presented at the August hearing. What's the foundation for that statement?
At the time that the packet was put together and till this point, we hadn't received anything new from the petitioner.
Then my follow-up would be, is this the first you'd heard of the assertion of the precedents based on economic hardship? Or-
Mr. Rooker we received some questions from Mr. Lloyd and are happy to clarify further if you would like.
Okay, well, the first is, is this the first you've heard of it, or have you had discussions with the petitioner about that issue?
The first discussions that we had with Petitioner about this issue were via email. I think Petitioner alluded to that as well after the initial hearing before this board. I'm happy to talk about those.
I'd like to hear
Sure.
the staff's response to that assertion of us being able to decide based on financial impact on the petitioner. Please.
Yeah, so the Court of Appeals, in fleshing out the practical difficulty standard, has said that there are sort of 3 criteria a Board of Zoning Appeals, or really a reviewing court, can look at. First, whether or not significant economic injury will result if the ordinance is enforced strictly on its terms. And then that's supposed to be coupled with a couple of other inquiries. Number one, whether or not the injury that requires relief is self-created, and then also whether or not there are feasible development alternatives for the particular site. So, mere economic injury is insufficient. The economic injury has to be significant. And then on top of that, a showing of significant economic injury should also be coupled with a showing that development alternatives are infeasible for the particular site.
Thank you. I have a couple other, if you, okay. I want to go, first of all, what I'll state, I don't want to ask the staff any issues about the windows. I want to concentrate on the parking. So you had in the findings that the smaller percentage of total ground floor was going to be injurious to the public. Could you expand on, I think that was point one and kind of point two. Could you expand on that at all in terms of helping us as a board understand a little bit more as to why in this current economic environment that's the case?
I'm so sorry. Are you talking about proposed finding for number one, the approval will not be injurious to public health, and then our finding for that?
Yeah, it looked like you were saying that it would be.
Okay, so the granting of the variance to allow for a smaller percentage of total ground floor area dedicated to non-residential use other than parking garage will be injurious. The overlay in which this building is located desires robust non-residential uses on the first floor. That's why it requires 50%. That's why we don't have that everywhere. We do have that here. It's desired here in our community documents adopted by council, and we do find that not meeting that regulation, especially at this location, is injurious because it goes against that desire. This isn't a side street that happens to be in the overlay. It's on Kirkwood. Yes, we have a lot of commercial. This is something we talk about a lot here and a lot at Plan Commission. We have a lot of vacant commercial across the city. We do not have a lot of vacant commercial on our main pedestrian corridor in downtown, which is Kirkwood. Reduced retail space devalues the interface between the public and private realm. Allowing limited small commercial spaces on the front reduces what those spaces can do to bring people to those areas, right? So the 50% could house more things than a smaller commercial space could, and that was considered when those percentages were created. And I will add, the code has changed quite a bit in the last 4 or 5 years since this petition came forward previously. We are slightly less car-centric. In this particular overlay, parking is not required. This particular development would like parking here, but it isn't something that the code is mandating in this area. So making room for it is not something that the code, again, which is part of the adopted, laws for zoning in this area, makes room for or requires.
And just to be clear, we were talking about a difference between 19% as proposed by the petitioner and 50% as required by code. Is that correct?
Correct.
Thank you.
Any other questions for the petitioner or for staff? Nothing? I have a question for the petitioner. Have you looked at, since you have identified that you have this parking need that is essential, have you looked at, since you have a very tall first floor, stacking parking on 2 levels, coming in 2 different locations, so that you can get back some of that floor space?
Yeah, we've, with Ryan, and I don't know, there's Ryan right there. Ryan, you want to comment on all the different various things that we've, he's looked at underground, going up a floor, and the economics.
Yeah.
Could you please identify yourself?
Ryan Strasser, Strasser Construction.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thanks.
Okay, yeah. As a follow-up to the last hearing, we went back and looked, and basically the idea of underground parking, the only way we could find to make that possibly work on the site would be coming off of Kirkwood, which has not been what everyone's desired, just because it would, like Randy said, have to be a long ramp down that because if you come in off the north side of the building, you end up with about 16 feet you would have to go down to get down to a lower level under, which just won't work there. There's not enough room in the building to ramp and meet kind of industry standards on that. A second floor, then we talked last time too about a possibility of second floor parking and going up. That is where I think in talking with Randy, the economics become a very hard thing, because you would try to ramp up off the back corner of the alley there, up at the northwest corner, and you basically would then change the whole structure of the building, because now you're elevated parking up above the retail space, everything else. You also get into whether you would end up losing a floor of residential, or end up, the building would need to be 5 stories to keep the same amount of beds on site. Then coming into the parking and trying to stack with some kind of equipment and everything, what you were going to run into is his parking in there, for the most part, is 1 spot per unit. A couple of the units up top have a couple of spaces. So the logistics of, I mean, you can't expect one person to come down and move their car so that you could unstack, and move cars with equipment in there. So it was kind of that.
It's just the uniqueness of the size of the lot. It's just, it's hard to get ramping, it's hard to stack, There are 15 residential units and 2 commercial units, which was also our plan to sell the condo commercial units as well. And I think under the new design, we have 20, right? Correct? 20.
It's either going to be 18 or 20, depending on some variables that we're working out for the PC. So.
At this point, under the design that was originally approved, some time ago, we had enough to have the 4 units. The 2 of the units at the top could have up to 2 spaces. Everyone else could have 1, and then we were allotting 1 parking space to legally run with each commercial space as well. That is still an objective that we, if we got our variance and got past the Plan Commission, that we would do as well.
So can you be specific on the amount of spaces that would satisfy your business plan?
The amount of spaces, at a minimum, I need 1 space per unit. Every unit needs to have a space that legally runs with it. So I'd have 15 at a minimum, and then the 2 condo spaces, so I'm at 17.
Madam President, if I can.
Yeah.
Okay. To the staff again, the amount of space, help me visualize this. The amount of space that's being proposed for the commercial space. Jackie, could you give me an idea through illustration of maybe something else in that area of what would that size be equivalent to in nearby businesses, if any?
Oh, let me look for a second. I think we figured this out last month.
Thank you.
Just a second. I'll say when we spoke to a realtor trying to decide, is the 50% reasonable at this location, when we were talking about our requirements, and he said he did think that it was doable, that it was leasable. He said the type of use that would typically go in for the space of that size would be restaurant. So this type of space, I think, would be for like a smaller retail. So let me see if I can give you an example, just a sec. If you have additional questions, you can maybe go forward. This might take a minute.
I was going to extend a version of that question to the petitioner, which is, what's your understanding if you were restricted to given what you're proposing, which is requesting us to grant just the 19% commercial space, do you have an idea of who it is you think is going to be renting that space?
Yeah, I think, and we've certainly have had interest and discussions with people, but I think what we're looking at is sort of like a small boutique retail person that I think it could be a small art gallery. It could be someone like, you may be familiar with, a place like Silver in the City or something like that up in Indianapolis. But any of the small retailers that I think, and you see some smaller retailers certainly on the square, but I think it's going to be a boutique shop. So it could be a small clothing store, and there's room. There's certainly, you could do a very small sort of takeout type of thing, like a small bakery, where you're like grab and go coffee and pastry or something of that nature. And those are all things that we've had discussions about. But from our perspective, as far as I've been doing this for a long time, and I've owned a lot of commercial property. I don't really want a restaurant tenant. The boutique stuff that we're doing it's something that, from a risk perspective, you can accept, because the greater goal is to have this. What we wanted was this owner-occupied housing. So the retail space meets the requirements. It does support downtown retail, but it doesn't force me to have to take on a significant more risk, or our partners to take on a significant more risk trying to lease, basically what amounts to 6,000 square feet of new retail space or office space. And so it becomes a risk factor for us. What's our primary objectives here? So I like the boutique space. I think we could do some really nice things that provide the kind of services that people who live and shop and visit downtown would come to. And I think it's a lot easier to lease than up to 6,000 square feet.
Okay, thank you. Back to the staff.
Okay. I will say, okay, so per the petitioner statement, it's actually, I should just go ahead and share this. Hold on. It's not one retail space, right? It's two. And so you can see them here shortly. Hold on, I'll go ahead and finish. And per the petitioner statement, they're about 1,100 square feet combined. So that.
Not combined.
Not combined, separate?
No, separately.
Okay,
So
thank
it's
you.
about 2,200 each, or combined.
That is about, I believe, the Five Guys on further down Kirkwood, if you're familiar with that. The Five Guys further east on Kirkwood is about 1,000 square feet. So, yeah, so we're verifying that, but I think that's one that's close by that's of similar size.
Theoretically, the size of the Five Guys restaurant just to the east, that would fit into one of the spaces that would be available at the reduced amount that's being requested by the petitioner. I want to make sure I understand that. Is that correct?
I believe so. I'm not sure if there is supportive square footage in the background that doesn't exist here.
I'm just,
but yeah.
trying to get an idea of spacing and a visual. Thank you. Appreciate that. Oh, one other thing is the petitioner allowed to open that up and make the two spaces one, or must it be two to the city?
Yes, they could be combined.
Thank you. So it could be a larger 2,200 square feet if they want it.
Not with the current design.
Oh, they're not continuous. Thank you.
I'll say that the bookstore, book corner at the northeast corner of Kirkwood, so immediately adjacent, the entirety of the footprint of that building is about 2,200 square feet. So obviously that's the use, and then the
Of that ground floor.
background storage of the ground floor of that building. Like when you look at the rooftop there. And again, I'll just point out, I'm sorry, I know we're belaboring this case here. We've got a long night ahead. But as the petitioner describes it, this is economically advantageous to him to have smaller retail space here and not wanting to have to fill a larger space. And while we understand that, the code just requires a larger space if you're in this location, if you want to build in this location. So like when Mr. Rooker was discussing that, that the case law does allow for the BZA to consider significant economic injury, there are caveats or that you also have to consider when doing that, which is why we don't normally talk about that, because it has to be not self-created. This is a vacant piece of land where they've designed a building that doesn't meet code and then want the city to let them vary from that. And there also have to be no feasible development alternatives. Maybe it is not feasible to have as much parking here as they would desire, but that isn't the only thing that can go here. So we just want to make sure that we're not kind of losing the forest for the trees, that when we look at the 3 criteria in code, one of them is that there are peculiar conditions that make it practically difficult for this property to be developed, period. And in this case, it may be difficult to develop this particular design, but we haven't seen anything, or the department doesn't believe that we've seen anything that indicates that it can't be developed at all without variance, that it can't be developed without variance.
Any further questions? Because if not, we are back to the board for action. And these, now, would we do the variances together, or it seems like there's a request from the petitioner to consider these separately? I think your recommendation was with one motion.
Sure, so as we often do, if there is more than one piece, and sometimes even in our recommendations, but if you would like to approve one and not the other, then you can split them and say we're approving the variance related to X and denying the variance related to Y.
Okay.
Otherwise, you would just approve or deny both.
Okay, thank you. I'll entertain a motion. If there's no further discussion?
I think the most important thing here that I see is the peculiarity of the site, per se. You have an elevation change from the south to the north, and also from the north and the south, and east and west. So it makes this site quite difficult to figure out how to fit this building and also be leveled and fulfill all the floor requirements, heights, everything else, which makes the height of the building the first floor much taller than what you would expect. And then when you try to put in parking in the middle, then you're going to come from the side of the building. You are already in an angle, and how do you make that all work? So there is a peculiarity to the site in terms of fitting the parking in there. I know so I guess my question is, are we deciding on just number of spaces? Because, of course, they want to put the parking in there, and they want to make it a condo, homeowner occupied, which I'm completely in favor of that, and we need more homeowner occupied places. So, what is the decision that we are making? Is just the commercial space that is, or
Yes,
the parking spaces as well?
So the variance being requested is a variance to the percentage requirement for non-residential, non-parking. So
I guess my question is, okay, so let's say we approve the 19% for commercial. Are they going to have to come and ask for another variance for the amount of parking spaces?
no, they're not over parking, Max.
Okay. That is one question. Okay.
I would follow up with what Barry said, which is, you may want to think about dividing it into 2 just to make it easier, and bifurcate it between the 2 just to make it easier to handle, because it'll be a big motion. That's just my suggestion on procedural.
Okay, so which one we want to take first? We can take the windows, it's the easier one? Okay, do I have a motion on a variance on the window percentage.
Well, I'll go ahead and take a shot at it.
Okay.
I move approval in case V-27-22 of the first floor facade large display window variance requested by the petitioner.
Okay. And then we're going to have, depending on what you're, so.
Is that legally sufficient?
I apologize, Commissioner Throckmorton. Can you repeat that motion? I didn't hear it.
Okay, it went right out of my head.
Oh, no.
Oh, no. I move approval of, let me get the right number, V-27-22 for the request of variance of first floor facade large display window size.
That's a legally sufficient motion
Thank
for
you.
the first request.
Thank you.
You'll need to supply a finding
A
to
finding.
support.
Right, so proposed finding number 1.
My proposed finding number 1 is, I believe the petitioner provided ample evidence that it would be well within what is found already on that streetscape, and might find that appropriate.
So the granting of variance will not be injurious to public health, safety, morals, and general welfare of the community. The proposal with the 51% of the ground floor facade as glass is in character, is found to be in character with the surrounding commercial properties.
I would agree with that,
And
yes.
protects the overall character of the pedestrian experience in the area.
Thank you.
And then finding number 2, the use and value of the area adjacent to the property, the granting the variance will not negatively, okay, so this one will stand?
I mean, that is the gist of the argument, which is it's going to comply essentially with what the area already looks like, and it's not going to be injurious, so, you know,
But the finding as written can stand for number 2.
Thank
And then
you.
number 3, the strict application of the terms of Unified Development Ordinance will result in practical difficulties in the use of this property. And if you don't mind, I would say that due to the 4-foot grade change east to west along Kirkwood Avenue, there is a larger than standard first floor height, which results in large expanses of glass, tall expanses of glass. That any larger, the sizes are not practical, that challenges the, I don't know, sort of,
Which is a peculiar condition
of
of
the,
this property.
the property. Can we piece together something, Jackie, on that? Does that, we kind of get to the spirit of what we're trying to say?
I think so, yeah.
Okay,
So basically indicating that it is peculiar on this lot that the grade change from east to west is such that meeting 70% would require excessive amount of glass compared to other buildings in the area.
yeah, a typical first floor commercial storefront.
Great, yes.
Okay, okay.
I'll second that.
Okay, so we're ready for a vote? A vote yes is for the approval of the variance.
Yes.
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 Okay, so that variance is granted.
Thank you.
We are to the second variance for the reduced percentage of commercial space on the ground floor. Do I have a motion?
I make a motion to approve V-27-22 in regards to the ground floor non-residential use other than parking garage use variance. This motion is based on the peculiarity of this site and the elevations from the north to the south and how they are going to propose the garage entrance from the alley. Also based on that 19% similar square footage commercial places are in use in Kirkwood for either food or retail, smaller food places or retail. Is that enough?
So that would be for the peculiar condition?
The peculiar condition is obviously the site and the elevation and the location. And I know it sits on the downtown overlay, but they are coming here for a variance based on, because they are on the overlay. If they were not on the downtown overlay, they wouldn't be here in front of us. So they're asking for a variance based on the peculiarity of this site. Does that work? No?
Well, you have to have the first two findings as well.
Okay.
So the granting of the variance to allow for a smaller percentage of the total floor
Will not be injurious to the public health, safety, morals, and general welfare of the community. Oh, no, I'm looking at the, sorry.
While you're working through that, I just want to make sure I understood. So on point,
Sure.
On point number 3, the relevant, I think, part is the last sentence, which is, there's nothing peculiar about the site that requires reduction in ground floor, non-residential, or garage space. I believe what you're saying is that there is, based on our findings. Okay, I
yeah.
want to make sure that's
Correct.
your first thing, is that it is,
Number 3.
yeah, number 3 is covered, okay. And number 2, you're asking about whether it's going to be injurious to reduce the 50% to 19%.
Correct.
And your point there was that it's not because,
It will not be injurious to the public
because
because there are already existing,
in the
current
near,
existing commercial spaces of similar size in the similar area,
okay.
correct?
And does that not also cover 1, or is that relevant to 1? Is that also relevant to point number 1? Reduce retail space D values, or is that a separate item? I'm asking just for clarification on the motion. The reduced retail space devalues the interface between public and private. Does
That's what this motion says. That's what this motion, that is what she said.
I'm asking what she just said about the reduction in space for item number 2
Yeah,
applies to
well,
item
and
number
what-
1.
And that's what we talked about as well, that the reduced retail space does not devalue the interface between public and private realm, and specifically on a Kirkwood street, in that point where it might become a walking street in the future, correct?
That's what I was
A
asking.
pedestrian street, correct.
Thank you.
Does that help you, Jackie? Is that too muddy now?
No, I think we can get the gist.
Sorry.
It's okay. Mike?
Okay.
This is just petition number 1, Jackie.
Can I briefly clarify the motion? Is the
Sure.
motion to require just 19%? Is that what I heard?
That's what he proposed. The site is proposing 19% of ground floor for commercial space, correct?
And I'm just asking, is your motion to require 19%?
Well, it has to be what he is proposing. He
As
cannot
designed.
change, correct? If he changes, then this
We
variance.
asked,
And-
yeah, that you be specific so that then he won't say, oh, I got a variance to have reduced, I'm only doing 5%. So if you set a minimum, you know, we just try to,
Yes, please. Everything should be granted according to the plans that we've been presented to us today.
that's fine, yes, yeah. So,
Yes.
you know, we often add that as a condition of approval.
Correct.
Right.
Please.
Okay, number 2, the use and value of the area adjacent to the property included in the development standards will not be affected.
Yes.
There's some on the screen, Flavia,
Sure.
I'll just go ahead and read it out and see if there's a portion you'd like to use. For number 2, the granting of the variance to allow for a smaller percentage of total ground floor area dedicated to non-residential use other than a parking garage will affect the use and value of the area adjacent to the property in a substantially adverse manner. You may want to change that. However, given the configuration of the site having an alley to the west and north, I would say the proposed parking garage entrance has been revised to be located off of the alley instead of Kirkwood in an effort to minimize disruption with the pedestrian zone and increase dedicated space, which increases the dedicated space up front, I would say, along Kirkwood of the non-residential use. This overlay desires robust non-residential uses on the first floor while providing, allowing, I would say, ample percentage for garage or residential space. A second retail space has been added to the ground floor where the previous design proposed the parking garage entrance, which enhances that public realm, as I said previously.
Sounds good.
So that was for 2?
Yep, and so then for number 3, the denial of the variance to allow for a smaller percentage of total ground floor area dedicated to a non-residential use other than parking garage use will not result, oh, hold on,
Yes.
will result, this is hard, this is like a halfway, these are some alternative findings. I think that your argument would be that the, I'm not sure, I'm not sure what makes it peculiar, so that one, I think we might leave up to you all to.
Yeah.
I thought when I was asking that question of Flavia that the response was that because there are other spaces in that area that are comparable, that what's being requested by the petitioner is not necessarily going to add to some kind of injury to that area or take away from it by making it larger. Was that your
Yes.
point,
Yes.
Jackie? Is that what you're asking? I'm just trying to get clarification. It sounds like that was the point that was being made.
Sure, I guess, what is peculiar about this site?
Well,
So is it that it
what's
is in an
peculiar
area
is-
where other,
is that the UDO's made a change, but that streetscape already has the characteristics for which the petitioner is asking, I guess is what I'm hearing. I don't want to
yeah.
state
Miss-
that as far as what Flavia's saying, but that's what it sounds like is the argument. That it is peculiar because the UDO changed something that already exists, can be found in that space. You can find 1,100 square feet retail.
I don't know, I'm not getting it, honestly. I mean, I understand what you're trying to do, I really, really, really do. And this is a very hard petition, because I think we all really support and like the project. You know, I think if we were a little bit closer, I mean, we're not even half of what this overlay calls for. We're not even 25% of, we're not even, 25%. This is a really big departure from what the overlay And the overlay is very specific to this area, and the overlay represents our community will. So I'm having a hard time thinking that it's not in some way injurious, because it allows less flexibility for the commercial space. And then what I'm just talking about now, we're talking about 10 and 15 and 20 years from now, what the potential is. And I guess the hard part for me also is that the spaces are not contiguous, so there's not a potential for there to be a 22,000 square foot or a 2,200 square foot commercial opportunity there. Is only 11 and 1,100. So it's further reduced, is what I'm saying. I mean, and I really do want to support this, but I'm having a hard time with that third. Yes, there are peculiar conditions in trying to fit a parking garage on this site, no doubt. But I think that speaks to is that a self-imposed situation? I don't, that's why I was asking a question about, we already have a high first floor height. Is there a way to come in at another level and get 2 7-foot parking, at that back portion? I mean, I don't know. Maybe it is impossible, and perhaps the small footprint. How does the size of the site for the category, the zoning category, how does that? Is this a small site? Is there anything peculiar about the size of the site?
No. I can
Okay.
show you so for reference, let's see, just a sec. The site's about 90 feet wide. The CVS site is about 55, 56.
Okay.
And so then some of the, the other properties to the south, I believe, are in the same overlay, and they're also actually smaller, not as wide as this site is.
So
I don't know.
are you suggesting if the retail space was contiguous, that might be something to consider? Or are you suggesting that we look at this with some kind of attachment of 25% retail space instead of 19%? Or do you see a solution in front of us that you would put forward?
That's not our,
Well,
in terms of a
Yeah.
number that we would arrive at?
Let me ask you this. If a motion were to be made for 25%, would that be something worth us considering, or is it a larger problem, do you think?
I think that we need to build, the peculiar condition of the site is really where we have to draw our finding from. I agree that the alley access is very difficult on this site, on the rear of the site and the side of the site. That is definitely, that creates a peculiar condition. But that peculiar condition is related to access. It's not really related to the percent of how many parking spaces there are inside. It's more of an access.
Am I able to ask a question of staff?
Yeah, sure.
So back to staff then. So if they were meeting the size requirement for the commercial space, it would be 6,000 square feet? Is that correct?
Is it is 12,000 square feet on the first floor?
What would it be if they were meeting UDO?
I'm not
And
sure.
the second part of that, Jackie, is what type of business would normally use that size of space?
When we reached out to a realtor asking about this question, he indicated that he thought a restaurant could fit in the size space that 50% would require. And I'm sorry, I don't know what that is right this second. Hold on.
Randy, can you tell us what the square foot for the first floor is?
So I think the gross area is like 12,000 and. Yeah, so it's between 5,500 and 6,000 square feet would have to be the 50%. I guess depending on how you measured the first floor square space.
Jackie or staff, aside from the restaurant, was there any other type of of business that the Realtor advised could possibly be in there?
No, we didn't discuss anything beyond that. We were basically trying to determine, is this unreasonable? Is this, more than is actually even possible at this location? Not because that's not something you all can vary. If the code needs to be changed, we just need to change it. So that's what we were trying to determine. Are they right? And 2,200 is a good amount for this area. And they said, yeah, that'll be easier to lease, but you could, at this location, you could lease something of the size required, which is roughly 6,000. And that was, so we didn't ask for a list of those types of businesses that could fit in. We were just trying to, does this seem feasible? And he indicated that he did think so, yes.
And I understand that. That's why I
Yeah.
asked. I was just curious. Thank you.
Uh-huh.
I think part of the difficulty is that this is, if, it's all location, and this is one of the best blocks and the best, location in Bloomington. So I think anything that you have there is potentially leasable. So I don't, yes, I think you could lease something small and you could lease something large.
Yeah, I'm not in realty, so
Yeah.
any helpful advice is appreciated. Thank you.
Yeah.
So what do we do from here? I don't have a second.
I think there was still one alternative finding that wasn't
One of
resolved.
Was number 2, Jackie?
Number 2, I think you got, you used the staff the staff proposed alternate finding, but we did not have an alternate finding for number 3. That's the one we just,
Okay, so
Yeah.
let me ask a question, please, of Mr. Rooker. So in terms of the hardship, I guess one thing obviously, condo unit, this is a type of residential unit that we would like to see in downtown Bloomington. And in terms of sort of the idea of the hardship, so, if we don't want to see office space here and we do want to promote residential, could we understand that really only any owner-occupied type of housing would typically require some parking that would go along with it, and so this would not be unusual for any project here, not just this project necessarily. Is there a particular practical hardship because of this site? I don't know. I'm trying to get at that self-imposed part. Like, is I don't know.
I think I understand what you're asking. You're asking whether or not the requirement in the UDO that the practical difficulties are peculiar to the property in question could somehow be associated with the fact that condominiums are being proposed?
Yes.
Yeah, I think you have staff's recommendation on that point. I don't think it's appropriate for me to supplement it.
Okay.
That's the requirement that you have in the UDO, which gives a
Right.
little bit more substance and meat to the requirements we see in state code, which is that you find practical difficulties, and then we have some additional guidance on practical difficulties, which are that there be a significant economic injury, and then, of course, that the injury is not self-imposed. I think you heard Jackie say, and she can correct me if I'm wrong, that staff's position is that there are alternative ways that this property could be developed, and therefore staff doesn't agree that the injury isn't self-imposed, or they would say it is self-imposed. So.
Okay. Just wanted to try and ask that, however poorly
Yeah, and I
I
think it
did.
would be better if Jackie just confirmed.
Yeah.
that-
sure, yes, I would confirm that. Yeah, and I would say, some of the things we've discussed, for example, like alley access. I don't know that there's been information presented. We reached out to engineering and public works as well and said, is there any way that these alleys, that grading could be done on these alleys if they were to, as Mr. Strasser said, have a separate entrance? It was definitely not a hard no. Of course, they said we would need more information, but I think we think that there are other options that could be explored besides just getting a variance because they already have a design that they would desire to build at this time.
Sure. And just to recap, if we do deny this second variance, What are their options?
Um,
I mean, they could always redesign.
Yes,
And
they
come
can always
back
redesign
and-
to meet code, or they can come back and I can look. There's a time frame normally that they can't come back, but you all can unanimously vote to let them come back earlier. I can't remember if it's 6 months or a year, so let me check.
I think it's a year, but let me check the rules.
Okay, so they could come back with a slightly different configuration, which could potentially increase the commercial ground floor space?
If they came back with, with a similar, they could come back with a similar variance. There just are some stipulations, I believe, that you having to vote, but I'll double check.
Okay. Okay, well, we
I have to, sorry, just point of order, just to correct myself, it is 6 months if a zoning petition is denied, if a petition is denied. So,
So we do have a motion on the, but it hasn't been seconded. So,
And for the third proposed finding, I would like to say that the peculiarity of this is the site, and it's a home occupied condominium, which would work best with parking. Peculiar to this building, so.
Sorry, Flavia, did you say the peculiarity you're suggesting is that the site will be homeowner occupied condominiums, which will work best with parking?
Correct.
Okay. So we will just say that that isn't a,
Yes.
yes, of course, okay, I just wanted for the record, that that's not a peculiarity of the site, but yes, that's on
Well,
the
the
table.
peculiarity is the elevation, correct? And how you're going to get through it and how you're going to fit parking in this site.
okay, do I have a second?
Yeah, I'll second it.
Okay, so then we have, can we have a vote, please?
I'm going to abstain.
No.
Yes.
Yes.
Okay, so that's,
that vote fails 2-1-1. The rules say it has to be the majority of the total membership of the board has to vote on a motion for the motion to carry.
okay. So the second variance is not granted.
Are there alternatives because of the way the vote went down?
I'd be happy to ask that of our council.
The motion wasn't, you didn't deny it either, so
Right.
you haven't taken any action at this point.
We haven't, it's no action. Okay.
And
So what does that?
You could, an alternative motion could be
So we could have
proposed
another vote.
and then
So we
voted
have
on. If you
another-
get 3 votes, that motion carries. If you want to continue the petition, of course, that's an option as well.
Okay.
And see if you can't figure it out at the next meeting.
So we have no action at this point. We can continue, we can have a new motion. What do we want to do?
What is the advantage of continuing this? We already continued.
Well, I guess, I think, would it be fair to ask for the petitioner to explore options to stack parking at the backside and look at a second access point to a higher level on a slightly taller first floor as an option that would increase the ability to have more? And I will grant you to answer that question, because that is a direct question
yes,
to
I
you.
would, I'd be happy to consider other options that could make the parking work in conjunction with the retail we're proposing and vice versa. Additionally, as well as if given a little more time, could present some other evidence that may help the BZA in determining particularly a full consideration of the economic impacts, which I don't believe have been considered, and providing evidence to that effect. I feel like this is like a new area for you, but in a nutshell, I'd be willing to present in advance if I'm given a date or if we need something that gives you the opportunity to look at it in advance of that, and I can meet with Ryan and make a determination of whether or not. And if we can't, we can't. I'm not going to present you something that we can't do either. So, but given the vote, if there's an opportunity to sway one more of you or both of you, then I'd be happy to give it the old good college try.
Okay. Joe, I don't know if you're going to continue to abstain on this vote, but what do you think?
Well,
I mean, what is-
it would depend on the motion, actually.
Right. Do you want to consider another motion at this time? Does
I'm
anybody else want-
always open to considering. I will tell you that what's difficult here is that I agree with the argument that's a lot to give up, but at the same time, I'm trying to balance that with the development of that space. So all I can tell you for sure is, as the motion is put in front of me, no, I can't vote for it, nor do I want to vote against it. And if somebody has something that's compelling, I'll listen to it. But I haven't heard anything compelling yet that would yet make me go one way or the other. I agree with what you had asked, which is, can there be alternatives created and brought back to us to review? Because the issue is the parking. I think what I'm struggling with is, if you look at the footprint of that building and you look at the footprint of the others around there, we will give up for a very long time the opportunity to put in some substantial commercial space there, okay? And I'm not prepared at this moment to give that up.
Right. But we're not the plan commission. We're not reviewing site plans either. So I think I would like to be able to talk a little bit further with staff and council outside of this forum, if we could. Is that, I don't even know if that's kosher.
Yeah, I mean, if you want to talk about BZA rules and procedures, we can
Yeah.
talk about those, but we cannot talk
Talk
with
about
you
this
about the
case.
specifics of any petition pending before the body.
I just feel like we're getting, there are questions that I'm even asking, or there are other design solutions that really aren't our purview. I mean, we just, nothing's going to change about the site. The site is the site. Right?
What we're talking about is what we're talking about is the variance in front of us. And the
Right.
variance in front of us is asking for a substantial reduction in the commercial space. And
Right.
my struggle is that that's a large amount of space to give up at a prime location, okay? So that's why I can't vote.
Okay, so if I were to put a motion out there to deny this variance, according to the findings of fact that have been presented, would that get a second?
And they would have an opportunity to come back with new plans, if needed, to the staff.
What was the question, Joe?
If a motion was put forward to deny the variance, then the petitioner could go back, redesign, try to get it through, and
If-
then if necessary, come back to,
If the petition is denied tonight, the petitioner has to wait 6 months to file something that, if it was similar, if it was the same variance request. But they can come to you before that if they have something similar, and you can vote unanimously to let them hear, to let it be heard within that time frame.
If they need a variance, if they can't meet
If
code.
they can't meet the code if they won't meet the code requirements. Mr. Rucker, were you gonna?
So
Yeah,
it's,
just to be clear, they could come back in 3 months, for example, not 6, but in that case, the board would just have to vote unanimously to allow that petition to be heard again within that less than 6-month period.
okay, so I put a motion out. Is there a second?
Is your motion to deny?
Yes. This request,
This request, as it was presented today.
yeah.
And then discuss.
We can discuss?
Yeah, I'll second it to discuss it.
Okay.
Well, I think, can I ask a question back to the, so you mentioned in there being able to quantify the economic entry part that would apply to number 3.
Yes.
That to me would be very helpful. It would be, because I think the idea that this is self-imposed, I don't fully agree with that. I think it's dictated by outside forces as well. And those outside forces are, if he changes this, then the economics of the project change, and also the funding and the whole long-term plan.
Tim, if the BZA board would provide me the opportunity, just on this variance, another opportunity to come back without a denial, so I could come back next meeting if the docket permits it and you approve it. I could address Barry's. I'll work with Ryan to seriously look at if there are other ways that we just have not looked at this, and see if there's alternatives that we might. And if there is, I'll propose them. And if they're not, I'll be candid with you about that we just couldn't come up with anything that works, in addition to addressing your component. And then we can have a discussion and let the vote fall again.
Thank you.
But further on that, if you are going to bring into the argument or the consideration the significant economic impact, I want to make sure that it's comparable to, you're going to be bringing it and saying, for this particular design for the condominiums. My understanding is that there are other ways to develop this site that would be economically feasible. So I also then, that's where you get into the idea of it's self-imposed. So I'd like to have an understanding of why it's not feasible to develop this site differently so that it is affordable when you do bring those arguments. That helps us.
Yes, and
Thank
I
you.
agree, and I also think just the BZA having a clear understanding of what the legal standard of review is would be helpful as well. So I'll at least bring that and try to educate based on what I know and what I understand the law to be, particular to my case.
So then, in that case, if, in order to facilitate this, if we were then to go ahead and have a second on your motion and deny it, and he would be able then to bring it back earlier if, under what circumstance? It's a continuance. If we deny the, I'm saying if we follow up,
If you deny my motion, we could move to continue.
Correct.
And we could ask Mr. Roper to provide some further guidance as well, just generally.
understood. I guess my question is, if we supported your motion, then he must wait 6 months, or he could still come back earlier?
If he wants to come back before 6 months pass, he can present the petition to the board. Before the board would hear it, you would just have to vote
Okay.
to hear it before the 6 months had expired, and that vote would have to be unanimous.
Right, okay. So I guess what I'm getting at is that it makes sense to me to just tonight to get this off the plate instead of a continuance, and then bring it back as a new continuance. I mean, as a new petition, as a new
Why not
petition.
just continue it? Because then you take care of the same thing, and
Right, so
That's absurd.
we prefer to hear not to continue this case.
Right, but just to hear a brand new request for a variance based on new information altogether, that starts it from scratch. We go at it, from this is, we're not worried about this 19%, whatever, but we're looking at the case fresh. New 20 minutes, all new public comment, the whole thing, as opposed to a continuance. I think it's cleaner and allows more flexibility for everyone involved. Am I accurate on that? Because it does open it back up for public, right? And it does give the petitioner a reset.
That's accurate. That would also allow Commissioner Coyne to participate.
So that's why I'm suggesting it, because it seems to me to be a better process. So if that's the case, then I would second your motion.
It's already second.
Oh, I thought it was second for motion. Oh, okay, thank you.
Okay, so I think we're ready for a vote. So a vote yes is for denial of the second variance, the commercial space variance. Ballard?
No.
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 Burrell?
No.
Throckmorton?
Yes.
Clapper? Yes. Okay, so that motion fails. So then we are to, now, So if we're going to continue, if we can, it's our only choice. We have to continue this case. So I will entertain a motion for continuance.
I make a motion to continue this case to the next meeting, V-27-22.
Do I have a second?
I'll second.
Okay, can I have a vote? Throckmorton,
No.
Clapper? Yes. Burrell?
Yes.
Ballard?
Yes.
Okay. Petition is continued to the October hearing. Okay.
Thank you.
Thank you.
And thank you for the first continuance, and sorry to take up so much of everybody else's time, but appreciate it. Thank you.
Thank you. Okay. Thank you, everyone. We are ready to go to case V-28-22, Warren with Chipotle. Staff report, please.
Thank you. This is a request from Warren Witt on behalf of Chipotle for a property on West 3rd Street. The petitioner is here tonight to request variances from entrance and drive standards to allow a driveway in the front parking setback, a variance from the maximum parking standards, and a variance from the pedestrian sidewalk connection standards in order to allow for a new restaurant to be built on a currently vacant lot that has a Monroe County Pizza business on it. So this is located at 3151 West 3rd Street. As I mentioned, it currently contains the former Monroe County Pizza restaurant. This is located within the Whitehall Plaza Shopping Center. It is zoned mixed-use mixed-use corridor. 3rd Street runs along the north side of this site, and then I-69 runs along the east side of this site. So the petitioner is looking to redevelop the site and remove the existing restaurant to construct a new Chipotle restaurant. It would be approximately 2,000 square feet. The site is accessed from within the Whitehall Plaza Shopping Center. There is not a drive cut on 3rd Street. That is an NDOT controlled road there. So there is no access to 3rd Street from this location, and everything comes from internal. As you can see, the adjacent businesses are all commercial, various restaurants. To the south, you got the Whitehall Plaza Multi-Tenant Center. So the petitioner is requesting, as I mentioned, to reconstruct the site with a new Chipotle business. This would have a 2,000 square foot restaurant. Approximately 22 parking spaces are being proposed as part of their variance request. There would be a drive-through on the west side of the restaurant or on the west side of the site, and then a driveway that runs between the building and 3rd Street. So the variances that are being requested, as I mentioned, are from the entrance and drive standards to allow for this driveway that is on the north side of the site to be located between the building and 3rd Street. They are also requesting a variance from the maximum number of parking spaces to allow for the 22 parking spaces that are being proposed versus the 10 that would be allowed. The Unified Development Ordinance stipulates parking based on the indoor dining area of the restaurant. This restaurant would have approximately 1,000 square feet of dining space. So based on that, they would be allowed 10 parking spaces. So that is one of the variances they're requesting. And then also the variance is from the pedestrian entry standards that require the side of a building facing the street to connect to and have a pedestrian entrance to that adjacent frontage. This particular site sits a good 10, 15 feet or more below 3rd Street. So there's a substantial grade change between the site and 3rd Street, which makes it very difficult for have that pedestrian connection. In addition, as I mentioned, 3rd Street is an NDOT road, and having a sidewalk run down there is not something that NDOT is in favor of, and you could not be able to have ADA access from the business to the road. So it certainly makes sense, and there is some unique conditions about the property that does not allow for the pedestrian entrance to be incorporated with this petition. So the petitioner has submitted elevations for the proposed building. While at this time they appear to meet most of our requirements, there might be some fine tuning that is necessary for that, but there are no variances that are being requested for the elevations or the architecture for the building itself. Just the three variances that I mentioned. So the petitioner has submitted a parking study to justify the number of spaces or the increased number of spaces that are being requested. These have been submitted from other locations within Indiana, from Westfield, from Emerson Avenue up in Indianapolis, one on Fishers, and then one up in Lafayette. However, the parking study that was submitted for the location in Lafayette has numbers that are not possible. That location only has approximately 8 parking spaces on site, and the parking study shows upwards of 40 parking spaces. So that information submitted for the Lafayette location is not correct and not really something we can even really use as a comparison. So the petitioner, as I mentioned, has submitted a parking study based on other locations, demonstrating that there is a higher need. However, certainly as the board is aware, we have to make findings that are unique to the property itself. The petitioner's argument in this particular case for the parking number is really more based on a disagreement in terms of how the zoning code is written that dictates parking number. They believe that the number should be higher. So as the board is also certainly probably aware, we've had several updates to the zoning code, to the Unified Development Ordinance. The parking section is certainly one of those things that has been updated. And in fact, we just recently changed, I think in the second round of amendments, how parking was calculated for restaurants, and changed that from a gross square footage of the building as a whole to the dining area specifically. So that was a cognitive change that we just recently made within the zoning code. This particular restaurant, this is a typical fast food restaurant. It's not any different than many other fast food restaurants. And so we don't find that there is a practical difficulty that is peculiar to the property in question that does not allow them to meet code in regards to the parking number. As I mentioned early on in the report, there is a substantial grade change between the site and 3rd Street that does present practical difficulty with connecting this building with a sidewalk connection to 3rd Street. So we are supporting that variance request. And then the third variance request is for to allow the driveway between the building and the street. So that is, again, something that we are not recommending approval of. That does not have to occur in order for that to be there. The parking area could certainly be located on the south side of the building. There's approximately 90 feet that is shown on the site plan between the building and the setback line, which provides ample area for parking to be located in that area. And the driveway between the building and the street is not something that is essential to the use of the site, that the site is unique in some way and doesn't allow for the site to be incorporated and built according to the UDO standards. So we are recommending approval of the pedestrian entry variance, but denial of the variance from the maximum number of parking spaces and denial of the variance to allow for the driveway between the building and the street. So we are recommending that the board adopt these proposed findings with the 3 conditions that are listed in the staff report, and I'm happy to answer any questions.
The BCA board. Okay, can we please have the petitioner's representative? If you could please state your name.
Good evening. My name is Mike Carmen, attorney. Jeff Fanio, Bond and Fanio Associates is here. A couple of representatives of the company are here, Lori Adler and Brian Chandler. There should be, can't see them here, a couple online, so depending on a raised hand at a later time, they may ask for an opportunity to add additional comments. I'm going to...
Excuse me, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
There are 2 distinct variances here. I'm going to defer to Jeff here in just a moment to deal with the one about the traffic lane in that location between the building and 3rd Street. Come back to deal with specifically with the parking question. And so we'll try to be respectful of time, and I'm not going to waste time talking about it now. Let Jeff go ahead and get started, if we may.
Jeff Fangio.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thanks.
I'm going to ask for the site plan to be brought up on the screen if I could to discuss it. As Eric described the site, it is bounded by I-69 to the east and 048 to the north. And when this shopping center was built back in the late 60s, early 70s, or somewhere in that vicinity, 048 and 037 was an at-grade intersection. And I don't remember the exact dates, but I think it was in the early mid-90s. They constructed an overpass and brought in the fill to elevate 3rd Street to the elevation it is now. And as Eric mentioned, it is 18 feet above the grade of this site. So we have some peculiar difficulties with this site from the standpoint that we can't have access to 3rd Street due to the elevation change. Plus, when the state took the right-of-way from this property, they created a limited access right-of-way, which means you can't have access from this site to 3rd Street. So having an access drive to 3rd Street is not a possibility. Plus, in addition to the grade change, there's a 3-to-1 slope from 3rd Street down to the site, and you couldn't manage that with a ramp down to the site. The other detail on this site that wasn't mentioned is that there is a 15-foot water main easement, and I believe that water main easement was put in probably to accommodate the ramp for I-6 or I-69 037, and it shows up as a dashed line underneath our entry drive on the north-south. Yeah, that's it there, and it cuts to the east, and then it goes due south. And when they put this line in, they didn't put it adjoining the property line. They put it right down about the west third of the site and then about the northern quarter of the site. So where you have a 30,000 square foot lot, 12,000 of it is encumbered by the sanitary or the water main easement, which had that easement not been there, we could reconfigure our site plan where we could move our building in one or two ways. If right here I'm showing the building just in scale, but if this easement wasn't here and I could build towards the setback lines, if this easement wasn't here, I could put this building in here, bring a driveway off of ingress egress over here, and access this site. And I think there's a sketch of that potential on the next, yeah, that one right there. So the location of that water main is dictating the design of this project, where I can't use the entire site because of the easement. I can't build over that water line with a building. In addition, we having the site plan that was shown in the petition is a way for us to have circulation to the site and also have stacking for our drive-through lane. And again, if that water main wasn't there, or if I had access to 3rd Street, I could reconfigure the site to meet the UDO, but because of these two conditions, I'm not able to. That addresses why we need to have that driveway in between the front setback and the building. And in fact, our access points really from ingress-egress easements on the south property line of this site and the west property line between us and Outback Steakhouse. So effectively, we have the front of the site, or the access point, is to the south. And if to bring traffic into the site, I bring it in from the south, but I have to get them back out. And because of the narrowness of the site with that water line easement, you don't have room to make a U-turn and bring them back out without creating that driveway in between the proposed building and the 3rd Street frontage. Those same conditions exist, and why we need not be able to connect the pedestrian easement to 3rd Street. The elevation change is just too significant to try to get a walk, steps, or ramps onto it, in addition to the limited access right-of-way that the state has imposed on this. They won't let us cross even with pedestrians because they don't want pedestrians onto their roadway at that point. And there's a fence there to keep that from occurring. So because of the water main easement, the grade change, and not having access to 3rd Street, we've come up with a site plan that makes the site usable and deals with the encumbrances of the 12,000 square feet of the water main taking, in addition to the elevation change and the limited access right-of-way. And that's all I have for now.
Can you put up the slide that I sent Eric this afternoon? He put in there. He put it at the end, should be at the end of it.
Sure, Eric, can you put up the slide that Mr. Carmen sent you this afternoon?
All right. So let's talk about the parking then. I mean, this is not a new issue to you. You heard this. Most of you were here about a year ago, a little over a year ago, for the Starbucks down on Liberty Drive. When they were asking for 33 parking spaces, you ended up with variance that allowed them 30. They had the same calculation. I believe it was for 10 for that Starbucks, and they had much the same issues. As an aside, do I think the parking schedule and the UDO is low, light? Yes, but that's not the point for tonight, because we're not asking to amend the ordinance, but we're trying to deal with what it is. And this site has some practical difficulties with the parking that sets it apart from not maybe all properties, but from many. And the issue is location. Not only the grade change, but the significance of that. This is a drive-to site. This is not a walk-to site. This is not a ride-your-bike-to site. We've got the interstate on the one side. You've got the divided 4-lane, 5 lanes, really right in front of the property down 3rd Street. You've got the grade change. You can't walk from where? There's no reasonable walking from residential structures or residential neighborhoods here. It is, in fact, the whole shopping center is a drive-to destination type use. This is a dine-in facility. Jeff used the word drive-through lane. There is no drive-through lane. It is a pickup window. Significant difference on the customer for a pickup who have to pre-order, come in and simply drive by and stop at a window and pick up, which is different than a drive-through, stop, order, wait for it to be prepared, then pick it up. It is a pickup window only, and otherwise it's a dine-in facility. And that's what the parking is. It has to. That allowed 10, that's everybody. Employees, customers, that's everybody. And the operations, and I'm going to turn over here to our Chipotle's representatives here in a moment to talk more about it. This is a chart that Lori tried to pull together to help show just more information about their parking demands and what they're used to. The 21 or 22 on this site is because that's what's allowed with the spacing requirements. 40% green space or impervious surface area, 60% impervious. To maintain that percentage, and there's no variance being requested on that, but to maintain that 10%, we could not get more than the 21 or 22 spaces on the site. That's not because that's what we'd like. We'd like to have more, but it just can't be done, and without other variances, which we're not asking for. So that really is a minimum. But the parking studies that Eric showed up there earlier, those were all parking customer only. There was no employee parking in any of those sites. That was stated in the petition. Those parking counts were based on customers only. So all those numbers you saw, plus it up by 6, 7, or 8, whatever the shift might require from an employee standpoint, and you have quite a bit more of a parking demand than even what that count states for, but specifically it was counted for what the customer demands were. And it's very practical, showing at different hours of the day. So you have some unusual circumstances or peculiar conditions with this property that I think supports the variance, and not the location, the lack of access, the drop below grade, the no reasonable access by at least pedestrian. It is drive here and park here or go away. There is no alternative. There's no street parking. There's no garage. There's no place to park except on this site. And that does not apply to a lot of places. Certainly does not apply to any site that's in and around the downtown area where there's street parking available for traffic that cannot fit on site. So I'm talking fast, but I'm going to stop there and ask Lori if you'd like to come up and address more on the parking issue. Thank you.
Could you please state your name?
Yes, good evening. My name is Lori Adler. I'm a real estate manager for Chipotle Mexican Grill. Thank you for
Swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Thank you in advance for your time and consideration this evening. So just like to kind of expand and maybe offer some additional perspective from the company's standpoint on how we use our restaurant, in addition to what Mr. Carmen shared. So specifically, I'll be speaking to the parking requirement, and we do, on every shift, have approximately 8 to 12 employees. So they would have parking needs at this site in addition to those of our customers. The parking studies that we gathered were only customer parking, not including those employee counts. So when you look at those numbers, that already validates that we need more than the 10 that's allowed by the code for our use. The West Lafayette numbers, we must have had an incorrect address on there, so I do apologize for that oversight. We'll get that corrected, but those were counts that were taken by our staff on those specific days as observed by the number of cars that were customer parked on those days, on those hours. So when speaking to the requirement to meet a variance, I think that the findings of the staff were that there is no injury to the public health, safety, morals, or general welfare of this, that the areas adjacent to the property will not be affected substantially adverse manner in connection with our variance request. So that really leaves the practical difficulties argument, which I think that we've shown that our use, which is a fast casual restaurant with a drive-through lane, does require more than 10 parking spaces to accommodate not only our customers, but our employees. And particular to this site, as Mr. Carmen shared, with the topography, the access, the boundary, there is no cross-parking in the shopping center. The covenants and the CCNRs, the covenants and restrictions, do not allow cross-parking, so we could not simply direct our employees to park in the parking lot to the south. We would be trespassing. And finally, if we built a 2,000 square foot dining room, then that would equate to the 20-ish spaces, right, per your UDO, but we just can't because of the size of the site, the water line easement, and just the site constraints. So approving the variance would relieve those practical difficulties for our use and for those reasons.
Thank you.
So if there's a hand raised right now, that would be another representative from Chipotle who's on Zoom would ask to speak, but if nobody sees a hand raised, then there is not anything more to say. So back to finish up then, when the staff recommended findings, I think the first two, I think you can just simply adopt those two. This the third one, which is usually where your debate settles on that issue, practical difficulties anyway, and I won't repeat it. For a third time, Lori mentioned them again, we think there are conditions with this site that present practical difficulties with able to be developed within it. And by the way, this has always been a restaurant site. This is the original Wendy's site that was there. If you lived here and go back enough years, you remember Wendy's. Most recently, it was the Monroe County Pizza. We're talking about another restaurant. So it is a site that is clearly suited for restaurant use. It's permitted use, but the parking demands requires more than what that would be allowed, and there's no alternative to the parking on site because of the location, the grade change, 3rd Street, the highway, and those other factors. We do believe those present practical difficulties and would ask you to support the variance. Thank you.
Thank you. Okay, we are to the board for questions of petitioner's staff.
Sure. First, this is a two-parter. First for staff, second for petitioner. So first to staff, which is the petitioner asserted that, could you put up page 114 on our, the overhead? So the picture that will come up is that overhead of the building and the parking lot just to the immediate south. So the petitioner asserted that cross parking is not permitted with the property directly to south, which was once the parking lot of the Kmart. To the staff's understanding, is that correct? And if so, if it is correct, could you explain to me what the restrictions are?
So we, certainly are not privy to private covenants and restrictions. What we look at and certainly what the board looks at are, what are the conditions that are unique to a property as a whole, or as the property sits. Certainly when you look at the aerial photograph and you're familiar with the site, you're cognizant of a large surface parking lot to the south of this that is vastly underparked, which is a great example of why we have parking maximums. But certainly, the parking area to the south, customers use that. They can go to multiple places within here. There are sidewalks all along 3rd Street. Certainly within the community, we want to encourage alternative transportation, bicycling, cycling. No location in Bloomington you only have to drive to. We're within a community. This is on a bus route. So there's lots of ways that you can get to this site. But to go back to your question, we do not look at or, regularly kind of keep track of private covenants and restrictions.
To the petitioner, if you could, please explain to me the background of the statement that there is no cross parking. What are the restrictions?
The Kmart building is now the in-home businesses there, and that parking lot to the north of it, leading up to the Easement Road that's just south of our property, that's all privately owned. That is owned by Brian Rentals, who happens to be, the irony of this, who happened to be your petitioner on the Starbucks parking variance a year ago. That's David Kamen. That's his property. He owns it. There's no parking easement on that property, and he's made his thoughts known on that point. So
the second part of the question then to the petitioner is, has there been a discussion with the owner of that property about leasing parking spaces, since this is a vastly underused, massive parking lot?
It's my understanding that Mr. Kamen, Brian Reynolds, who owns that property, has already made it known he's not interested in talking about parking on his property.
There you are, Dave. Hold on.
Well,
There will be public comment, and you are welcome to make that comment. But let's stay with the petitioner. Your statement has been entered into the record, okay? And that is my question. I would just like to know if a discussion has been undertaken to request some kind of an agreement.
Well, it may be that David's going to correct me. When I asked, the representation came back to me, not from either of these two, was that Mr. Kamen had made it known he was not interested in allowing parking on his property. Now, that's not correct. David's going to be here to correct that.
Okay, I just want to understand what your perspective is and whether you or anyone else that represents this property had reached out to ask about reaching an agreement to use the spaces that are there. And you're saying that you have reached out, or someone has, and you have been told no.
That's what was reported to me, yes.
That was what was reported to you. Thank you. That's all I need right now, and anything further will follow up. Thank you.
Then we are to the public. Is there anyone here this evening who would like to comment? If so, please step to the lectern and state your name, and I will swear you in. And you will have up to 5 minutes to make a comment.
Dave Kamen here. And I am Brian. I'm the president of Brian Rental, Inc. I think it's a
Excuse me, Mr. Kamen?
Oh,
One second. I need to swear you in. Do you swear to tell the truth,
tell
the
the
whole truth,
truth,
and nothing
yeah.
but the truth? Okay. You have up to 5 minutes.
Okay.
Thank you.
I think it's just a misunderstanding because I think Mike was misinformed. So I don't think it was an intentional misinformed, but nobody ever called me, and I would further like to speak in favor of having this. That's a dead corner. Small business didn't have the visibility that they need. They don't have the wherewithal. A chain would. They have the power of their social media and so on and so forth. So I am most certainly in favor of this, having a Chipotle restaurant, contrary to what anybody would say. But I don't think that he's saying that I'm not in favor of it, because I am in favor of it. And if somebody approached me, I probably would have known about it. Nobody called, wrote, or sent me flowers. Nothing. Nothing happened. So I think it's a misunderstanding, and I would absolutely be thrilled if they bring Chipotle there. It'd be a great asset, bring a lot of customer base, help the property that I own, and I do bound them on 2 of their sides, as you saw. And I was kind of surprised when Mike said that, but I don't know where he got that information. He was clearly not informed, and I am clearly in favor of this, and I'd like to see him come through. And nobody ever, like I had stated, nobody called me about this. I actually found out we were working on another deal, and Mike was there and said, hey, Chipotle he's going to be at a BZA hearing. I said, great. You know, I met him in the hallway on another meeting that we had. And so I was kind of taken by surprise that somebody would misinform him. But I'm here to state that I'm 100% in favor of this, and I'd like to see this go in. And if anybody's got any questions, or if anybody wrote me a letter, let them come forth, because nobody called me. And I'm friends with Brian, and Brian represents Chipotle, and he's welcome to call me at any time. So my son Eric's here. Maybe he can weigh in too, and he's starting to take over some of my duties at my tender young age here. So, and I believe that he's in favor, but I don't want to speak for him either. But if you have any questions, feel free to ask me. Okay.
Could you state your name?
Eric Kamen.
Do you swear to tell the truth, the whole truth, and nothing but the
Yes.
truth? Okay, you've up
Yeah,
to
I
5
just want
minutes.
to say about the parking thing. I mean, we did the Starbucks, and it took us 5 months, I believe, to get that done, and I just hope that doesn't happen again. That's about it. I just think Chipotle needs more parking, and they should get it.
Thank you.
Thanks.
Is there anyone else here from the public who would like to speak to this petition? Please, step to the podium. Okay.
My name is Craig Doman.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, up to 5 minutes.
I'm with Century 21 Commercial. I am the listing agent. I'm the realtor for this property. And I'd like to thank the BZA for all your time and dedication to this. I am also in favor of allowing the parking as requested by the petitioner. I didn't plan on being here this evening, but I was like, I'm the listing agent. They might think I'm biased. What do I have to contribute? Well, I'm not just the realtor. I've been in Bloomington for 12 years. I'm an IU Kelly grad, and I serve in the community in different capacities. And Bloomington's my home. So I'm in favor of the allowing the parking as requested. We're not destroying anything, not knocking down any trees. We're going to keep it, as has already been mentioned, it's been a restaurant for decades, and we're going to keep it that way. Right now, it's an eyesore. I couldn't take my kids there a few weeks ago because there were trespassers on the property. The whole thing has been graffitied. I would love to see it a good business that I personally live on the west side, closer to Ellettsville, but I'd love to see something on the west side that's not a burger or pizza, and I like Chipotle, so yeah, I'm in favor for it.
Thank you. Okay, so then we are back to the petitioner. Is there anyone else from the public who would like to speak to this petition? Is there anybody on Zoom?
On Zoom, we received some messages from a member of the public, but let's see. Let's see if they want to unmute to speak. Are you there?
Yeah, hi. Yep, I'm here. I'm Ananya Mani, and I'm a resident here. And I think.
Excuse me, can you please state your name?
Ananya Mani.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, you have up to 5 minutes to speak.
Okay, thank you. I think I'm completely in favor of this. It's hard for brick and mortar kind of system to sustain there because it barely has any visibility. And I think it's a good idea to have Chipotle on the west side. I personally stay on the west side. Having said that, I've stayed on the east side. We would like to not travel, especially drive towards downtown area or east side, just for sustainability purpose. So I think having it on the west side is a good idea. Thank you.
Okay, anyone else on Zoom?
I don't see any raised hands, and I haven't received any messages.
Okay, thank you. Okay, so then we are back to the petitioner. Actually.
Oh,
yeah?
sorry, he has 5 minutes left.
5 more minutes, okay. If you have any comments further that you'd like to make.
Not to belabor it, but just want to make sure it was clear that granting the parking variance or not doesn't change the green space. It doesn't change the lot layout. Lot layout, but it does not change the impervious surface versus pervious surface ratios. It doesn't change. We're not sacrificing green space or landscaping for the parking that's being requested. Out at that point. But with regard to even if the concept of other parking available, from an investment standpoint, building the building, which is not cheap, you're generally not going to be dependent upon the grace of someone else before you put your investment in the ground. Whatever Brian Rental may or may not agree to do today with regard to parking, someday it'll be somebody else. It won't be Brian Reynolds owning that property forever. They've got their own issues, and I'm sure David's aware of it. He can't afford to touch the at-home building, because if he touches it exteriorly, he's going to be ripping out paving. The ordinance is going to require some compliance issues on the parking and paving in that C. There are other triggers that are out there available that would ultimately someday likely change that parking configuration. We're looking at our property, our site, as a standalone, self-contained. You build what you need and operate what you need within the lines of what you have. And to be able to do that, we need the parking variance for those additional spaces. It's not an unreasonable request. There are, I think, several supporting reasons for that. I know Eric says, well, we want people to walk there. You can look at the photograph again. It doesn't, unless you've been out there and just looked and stood and looked at the mound's called 3rd Street and the 18 feet of grade change, and where this is tucked off down in the corner, this is not a walk-to site. It just isn't. And that's not going to change regardless of what you do tonight. It is a drive-to site, as is much of that shopping center, as is Whitehall Plaza and Whitehall Crossing across the north side of 3rd Street. So the variance is needed. The numbers that Lori was getting into, and that one brief time we had her other chart up there demonstrates that the actual parking demands are much greater than what is being requested here, but we fit the parking demand to what the site would allow. And that's why it's maxed out at that. And from a business standpoint, we learn to make do with that. That's all we can do. But we need that. 10 spaces for employees and customers, both. I just would ask you to support the variance. Thank you. Anything to add? Okay, thank you.
Okay, thank you. Okay, so I'm back to the board for action. I will entertain a motion.
This is Eric. I would move to approve all the requested variances on petition V2822.
Okay, so we're just going to need some additional proposed findings, some alternate findings.
Yeah, I think it's a unique property in the sense that there's only 10 spots being allowed. Employees are going to take most of those. They're clearly going to fill them up. And then people, regardless of what agreement Brian Reynolds has, customers are going to park across the street. And I don't necessarily want to create a scenario at an intersection which is blocked basically from view anyways, where people have to cross an easement street to get to the restaurant where they're going to eat. They're either going to park in Outback or they're going to park in the at-home, because it's going to fill up right away. So I do think there's a safety issue of requiring people to cross the street. And I do think, given the water line and the fact that this is literally just one ginormous piece of asphalt that they're building on top of, it seems kind of silly since it's not going to change any of the impervious surfaces. So given all those reasons, I think we should approve all the requested variances.
Okay, so,
I can help draft that better.
so the proposed finding for the peculiar condition, because the recommendation was for denial of maximum parking number and proposed drive between building and street. So let's just kind of summarize the proposed alternate finding for the variance for maximum parking because of the extreme lack of pedestrian connection to this location. Correct. And the proposed drive between the building and the street because of the disconnect and the lack of visibility from the adjacent roadway, and the existing sanitary, is it a sanitary sewer? Water sewer easement creates a difficulty with layout, building layout.
Thank you.
Do we need more than that?
Yeah, I think that's fine. There's also a proposed finding in the petitioner statement.
Yes.
For this one, which I think covers the items that you mentioned.
Okay. The topography, the granting of the variance will not be injured. Peculiar to the property is the water main easement restricts the use of the property and the building setback lines, limiting the ability of the site to accommodate access, drive-through lane, separate parking from pedestrian access to the building. Is that one?
Yes, I believe so. And then in addition to, I think we can use that in addition to what Eric said to formulate a finding, and then we can bring that back next month to make sure that that's,
Okay.
but I mean, I think we have the
Okay.
idea.
I'd like to add to that the lack of visibility from the adjacent roadway.
Sure. Yep.
Especially for the drive between the building and the road. Okay, so do we have a second?
I'll second that.
Okay. Any discussion?
Yeah, I'd like to just respectfully disagree with the maximum parking standards request because this property was developed years ago, and as that property stands now, there are hundreds of parking spaces there. The property in question is at the end of that parking lot. There's no one that's going to be speeding through that area because there's nowhere to go. So I don't agree that it's a safety issue based on where the placement of the restaurant is. There's ample parking opportunities available that are just as close to the building as any of the others that have large parking spaces along that area that aren't being redeveloped. It's a pickup model. That's what was conveyed to us. Come in, pick up, leave. And I think, that doesn't tell me that they need 20 more or whatever many other spaces. And I think times changed. I think that what we're trying to do is move along towards those times, which is, that's not the model anymore. We don't need that many parking spaces, and there's a reason for the UDO. And granting these variances just kind of shoot us in the foot while we're trying to move forward. So that's essentially, my disagreement with that. There are other avenues that do not require a variance. And As I say, respectfully disagree. I don't think that those are peculiar situations. I think that those are desires, but I don't think that they warrant a variance. Thank you.
Thank you. Anybody else?
I think coming back to the use and value of the area adjacent, included in the variance not being affected, I think they made it very clear, the petitioners made it very clear there will be an issue if the variance isn't allowed, because you're going onto private property. All those spaces out there are owned. They're owned by various individuals, corporations. What this group is going to own is only going to be enough for their intents and purposes. So if the overflow starts going into other businesses, that's an issue. So to me, that's the reason a variance would support the findings of proposed finding number 2, because without the variance, you're creating legal issues potentially over time with people crossing private property lines, and that could create a whole nother can of worms, I think, so.
And I recognize and acknowledge that position. However, the discussion tonight indicated that there is an avenue available for an agreement to be made that has not been pursued. And since the petitioner has not pursued it, I'm not inclined to do it. If there was a definitive answer that there could be no agreement to use a vast parking that's available, that there was a discussion and it was refused, I would easily vote for the variance. But that hasn't been pursued yet, and I think that there's no need to build more parking when there's plenty available, and from our public comments, it indicates that there's possibly an agreement that can be made there without the need to build even more parking.
Okay, thank you. Thank you. Anybody else? Okay, if we're not, we are ready to vote. The motion on the table is in favor of all 3 variances.
Yes.
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 Nope. Yes.
Okay. Variances are granted. Good luck. How's everybody doing? Okay, we are to Lamar Advertising, AA-31-22, Lamar Advertising Company. Staff report, please.
Thank you, board members. Michael Rooker, City Attorney. I'll be doing this staff report. I think Jackie has the controls over there. This is, you can go to the next one. Jackie, when you're ready. This is petition AA 3122, and it's an administrative appeal related to a sign located at 1800 North Kinzer Pike. That's just across from Kroger North, so it's the billboard just across the street from there if you're familiar. You can move along, Jackie. As I said, this is an administrative appeal of an NOV that was issued on June 10th, 2022 for an unlawful electronic reader board sign. You can go to the next one. Just to give you some background on the history of this particular NOV and the petition here, on April 1st, 2022, staff observed an electronic reader board sign at the site. We'll hear some testimony in just a minute from Senior Zoning Compliance Officer, or Planner, I should say, Liz Carter on that point. On April 25th, an NOV was issued to the petitioner. That NOV was issued on the basis that we had a lawful nonconforming sign that had been altered, and therefore it had to come into compliance, which would not be possible for a sign of this type, and so it had to be removed. It was subsequently discovered that, in fact, a variance had been granted in 2010 for the existence of the sign, so it was not lawful nonconforming, and as a result, staff withdrew that original NOV and considered the matter closed for a brief moment before we had a moment to reconsider and realize that we, in fact, had an electronic reader board sign at the site, which is not lawful under 20.04-100G of the UDO. And so on June 10th, 2022, an NOV was issued, a subsequent NOV was issued for a violation of that section of the UDO. As you can see, we've just scrolled through a couple of pictures taken on April 1st of the sign, demonstrating that it's a digital sign that covers a substantial portion of the face of the sign. You can go to the next one, Jackie. There are a couple of requirements. You can go to the next one. So I'll just go on. She'll pull up the next slide in a second. There are a couple of requirements in the Unified Development Ordinance associated with electronic reader board signs. First, no more than 40% of the total area of the sign may be dedicated to an electronic surface, and the intervals between changing information displayed on the sign can be no shorter than 20 seconds, so 20 seconds or longer. Also, just to read the definition of an electronic reader board sign for the board, an electronic reader board sign is any sign with a fixed or changing display or message composed of a series of lights that may be changed through electronic means. You can go to the next one, Jackie. So, on April 1st, staff observed a sign, a digital billboard at the site that was covering more than 40% of the total sign area, as you can see in the pictures, and the intervals of the message was changing at approximately a rate of every 8 seconds as opposed to 20 seconds, which is the minimum interval in the UDO. On June 17th, we received a timely appeal of this petition from the owner of the sign, Lamar Advertising Company, and they made a couple of comments in the appeal that they submitted to the board. I'm going to briefly address those. The first point that they made in the appeal that they submitted was that the staff could not submit a second notice of violation after submitting the original notice of violation and withdrawing it in April. That's simply not the case. There is no rule that staff is familiar with or has ever encountered that suggests that you can't issue a second NOV when an initial NOV has not been adjudicated or fully litigated through a quasi-judicial body like the Board of Zoning Appeals or all the way through a court. So there's nothing that would prevent a second NOV unless the matter had been fully litigated. The second argument raised in the appeal from the petitioner is that when the variance was issued in 2010, the variance only required that the sign comply with a single element of the UDO, and that's lighting standards, that in fact the variance implicitly relieved Lamar of their obligation to comply with any other term of the UDO. Again, that's not the case. It is the case, in fact, that while the variance specifically called out lighting requirements as being an element that needed to be complied with, the rest of the UDO still applied to this sign. It would be extraordinary for the Board of Zoning Appeals to grant a variance from all requirements without specifically and explicitly stating that they were going to grant a variance from all requirements of the UDO. That didn't happen in the variance in 2010, as you can see in your packet. And so without that explicit relief, it's not present. Furthermore, the BZA specifically required that the petitioner in this case had to obtain a sign permit after obtaining the variance. The only reason the BZA would require that the petitioner would obtain a sign permit would be so that staff could review the petition to make sure that it complied with the other terms of the UDO. Furthermore, when that sign permit was issued, it recited the requirements in the variance and explicitly stated that the certificate did not exempt the property from compliance with any other requirements, which again explicitly suggests that the BZA and planning staff and all parties were treating this sign as required to comply with all elements of the UDO. Finally, just to respond to a couple of points made by the petitioner in this case, the petitioner suggests that, on the contrary, the parties all assumed that compliance with the UDO was not required except for the lighting standards because there were certain elements of the sign that were not compliant with the UDO. For example, the petitioner suggests that the sign incorporated changeable copy. The sign did not incorporate changeable copy. At any point, changeable copy in the UDO is defined as a sign that displays words, lines, logos, or symbols that can be easily changed to provide different information without altering the face or surface of such sign. The traditional changeable copy sign would incorporate something like black and white lettering. That's not what we have here. We have a billboard. Even though it was a static billboard, it would be completely changed when it changed from one advertisement to the other. The other argument in the appeal is that the sign was not compliant with the base requirements for the sign base requirements in the UDO. We do agree that the sign was not compliant with the base requirements in the UDO. That element was missed upon review in 2010 when the variance was granted. It was not included as part of the variance. Perhaps it should have been, or it should have been noted in some way, or subsequently noted by staff. Sometimes that happens. However, the fact that staff may have missed a particular element of this sign that should have been included in the variance does not imply that the variance was intended to relieve Lamar of its obligation to comply with all other terms of the UDO. Lamar's final argument in their appeal is that the billboard is simply not an electronic reader board. The suggestion here is that a layperson's understanding of an electronic reader board would not note this sign as an electronic reader board. That's beyond the purview of the Board of Zoning Appeals. Again, it's right up on the screen. The UDO defines an electronic reader board as a sign with a fixed or changing display or message composed of a series of lights that may be changed through electronic means. It's undisputed that the sign in question utilizes lights to display a message that may be changed through electronic means. It's clearly an electronic reader board sign. I think Ms. Carter may have some additional comments or some additional evidence to present very quickly.
Liz Carter, Senior Zoning Compliance Planner for the Planning and Transportation Department. I'm going to share my screen here in one moment.
Hold on, we're just having technical difficulties. It'll be just a second.
Apologies, the file is very large because it has large video files in it. I was the staff member that did the investigation of this billboard starting in April. The first video you're about to see was taken on April 1st, 2022, and is reflective of what I observed. So this is from a stationary point looking at one side of the billboard. As we look at it, you can see that the image is changing, as Mike Rooker said, roughly every 8 seconds or so. The next video is from April 8th, so roughly a week later. One side of the billboard was being worked on. As the car passes the billboard, you will see that the other side was still in use and still being used as a digital billboard. Okay. The last video is from June 9th, 2022, and is also an accurate depiction of what was observed. Apologies, it's a little hard to see at first. We started kind of early, it's a long one. So this is heading down the bypass. You will see the billboard kind of in the center of your screen get larger as we go on. Again, it's still a digital billboard, and the image was changing roughly every 8 seconds. This was also a fair depiction of what I observed that day. We lost it a little bit in the turn there, apologies.
Okay, is that it, Liz?
It is. Thank you,
Okay,
Mike.
thank you. And just a reminder, because this is an administrative appeal, staff does not issue a formal recommendation on the petition.
Thank you, but then we go to the petitioner for their opportunity to speak. If you could please state your name?
My name's Alan Townsend, 111 Monument Circle, Suite 2700, Indianapolis 46204.
Do you swear to tell the truth, the whole truth, and nothing
I
but the truth?
certainly do.
Up to 20 minutes.
Thank you. As I said, my name's Alan Townsend. I'm the attorney for Lamar Advertising. Lamar is one of the largest and most respected outdoor advertising companies in the country. Before I discuss this matter, I'd like to introduce you to Jason Graham, here to my left. Jason works for Lamar at its office in Indianapolis and is responsible for all outdoor advertising signs in the city of Bloomington, Monroe County, Indianapolis, and the central Indiana area. So how did we get here? In a letter dated, I think, June 10th, 2022, the Planning and Transportation Department issued a notice of violation to Lamar regarding the outdoor advertising sign you've seen here at 1800 North Kinzer Pike. Lamar responded in writing 7 days later and explained why the notice was mistaken. Lamar did not receive a substantive response from the department again until September 16th, 2022, when it received the staff report. I've given you a booklet because I think it's important for you to understand how we got here. And I'm going to kind of go through it quickly. A lot of the documents, we don't need to study or memorize, but it kind of provides a timeline of how we got from point A to point B. So under tab 1, I've learned, because of this dispute, that there was some kind of a settlement agreement entered into all the way back in 2007 between an entity called Hoosier Outdoor Advertising Corporation and the city of Bloomington. What you'll see on page 2 of that document, although the pages aren't numbered, is that there seemed to be two things of import in that agreement. Number one was listed in paragraph 4, and that's that the city of Bloomington had some signs on College Avenue that it wanted taken down, and they belonged to Hoosier. In paragraph 5, the deal that was made is that Hoosier, we're going to allow you to put up a traditional outdoor advertising sign somewhere in Bloomington at a site to be determined that everybody can agree upon, but we're going to support you doing that. What you see under tab 2 is that a site was found, 1800 North Kinzer Pike. By this time, Hoosier has sold its inventory to Lamar, and Lamar is the name on the agreements going forward. That's why there's the change. So the variance is applied for in 2010, in October. Under tab 3, you see depicted exactly what was built. There's a color photo of what's called a monopole outdoor advertising sign in the location you've seen now in the video. Tab 4, this is an important document. This is the BZA approval of the variance. And I'll tell you the most important language is on the very first page. Number 1, petitioner must receive a sign permit. The variance was approved. And number 2 says the sign shall be permitted to be lit within the standards of the UDO. That's it. 2 requirements. So tab 5, you see the permit that was indeed issued by the city of Bloomington for the outdoor advertising sign in July of 2011. Tab 6, you can actually see the location where the sign was then built. You're probably familiar with it. You probably drive past it. Sits next to the kind of IMI Rogers Sand and Gravel Pit. What you see in tab 7 is we fast forward. Life is without controversy for the better part of 10 years. In tab 7, Lamar applies for an electrical permit. It's granted. In tab 8, you see the digital sign. It was really a conversion from what's called a static to a digital. And I've given you 3 different depictions of what's shown on the digital at any point in time. You've seen others in the videos. Tab 9, fast forward to April 25th, 2022, the Planning Department issues a notice of violation to Lamar saying, hey, you can't do that. Tab 10, you see my response. By that time I'm involved. I write a response on May 2nd, 2022, send it back to the planning department. I copy legal counsel. Tab 11 is the response to that. I get an email from Mr. Rooker saying, hey, notice of violation withdrawn. More importantly is the part I've highlighted in here where it says, and the matter is considered closed. Tab 12, now we're into June, and the city's back. A new notice of violation letter for the same sign. Tab 13 is my response, dated June 17th, 2022, that leads us to us being here today. From June to September, we really hear nothing, but under tab 14, we get the staff report that finally provides some more clarity on the city's position. And under tab 15, I've given you a kind of a detailed response to the staff report about why they're mistaken. So let's talk briefly about that first notice of violation. The staff has taken the position that to send a notice of violation, to withdraw a notice of violation is irrelevant. I believe that's incorrect. I will tell you the first notice mistakenly claimed that the sign was in violation of the UDO and needed to be removed. After receiving it and studying it for a brief period of time, it didn't take me long to realize that somebody at the city didn't know about the settlement agreement with Hoosier Outdoor, and it didn't know about the variance. So when I wrote them back, I made them aware of that. And then I've got Mike's email in May saying notice of violation withdrawn, and the matter is considered closed. I'll tell you, to lawyers, language like that means a lot. When you say the case is dismissed or the matter is closed, that means you have closure and you don't expect to hear about it again. It might be different if the message we had gotten said, hey, we're going to withdraw that, but Alan, you need to understand we're still looking into this. That's not what it said. So I do think that means something, and it's certainly a turn of events that affects Lamar's due process rights and really basic fairness. But let's talk about the UDO, because I think that's what's important here. The staff report claims that when the BZA granted the variance for the sign, and the variance was under tab 4, that it imposed the condition that this sign shall be permitted to be lit within the standards of the UDO, and the staff's position that it also meant, or what the BZA really meant, is that, and you still have to comply with all the other provisions of the UDO, even though that's not what the variance said. I'm telling you that's not right. Under Indiana law, and I'm sure you guys know this because of the seats you sit in, it's the Board of Zoning Appeals that has the power to grant variances from development standards, and it's the Board of Zoning Appeals only that has the authority to impose reasonable conditions on those variances. So let's go back to 2010. What did your UDO say? There were 7 ways the 2010 version of the UDO impacted signs. Number 1, you just couldn't have an off-premise sign whatsoever. Signs like what you see here weren't allowed. Number 2, they couldn't be freestanding with just a pole. They had to be attached to a building somehow. Number 3, your UDO required that all sign bases have an aggregate width of 40% of the total horizontal width of the sign. So that means if you're going to have a sign that's this wide, you've got to have a base that's at least 40% of that. 4th, the UDO said put landscaping around the sign. 5th, the UDO said freestanding signs are allowed to have changeable copy so long as the changeable copy area does not exceed 40%. 6th, the UDO required that electronic reader boards shall not comprise more than 40% of this total sign area. And 7th, the UDO said sign lighting. You have to comply with the sign lighting trespass regulations in Chapter 20.05. So, the City of Bloomington BZA, the people who used to sit in your chair, and on December 16th, 2010, they granted this variance. Out of all these design standards I just walked through, when they granted the variance for the sign, it required Lamar to comply with exactly one and only one. It did not mention any other standards. So when the BZA imposed the condition that the sign comply with the lighting standard, it excluded compliance with all the other standards not mentioned. Ladies and gentlemen, there's no other way to read that variance. So the drawing submitted by Lamar, the one I gave you in tab 3, showed exactly what the sign is going to look like. It clearly reflected that Lamar was going to build a pole sign. It was going to be off-premise advertising. You're going to change the copy, and it was going to have a pole that was less than 40% of the width, and there's going to be no landscaping. The UDO at that time did not allow any of these things. Yet that's exactly what Lamar built. That's what everybody knew Lamar was going to build, and that's what the city gave him a permit for, because that's what the BZA said had been approved. The staff report goes on to claim that, well, sometimes violations of the UDO go unnoticed. I think in some instances, that's probably right. It's a lot to keep track of. That's not the case here. This was no oversight. The documents attached to the staff report that they gave you clearly demonstrate that what Lamar built was exactly what Lamar proposed, and it was a pole sign for an off-premise ad. It had an IU advertisement on it. Everyone understood that the BZA had granted a variance for Lamar to construct a sign that would not have to comply with all these other UDO requirements, except lighting. So the staff report contends that the sign was required to comply with all the provisions of the UDO because that's what the certificate of zoning compliance required. I'm going to try and put my hands on that. That's under tab 5. So it's this single-page document, and what they're referring to is the very last sentence above the signature that says, this certificate does not constitute the issuance of any required permit nor exempt the property from compliance with any other requirements. And that's the city's argument that, well, wait a minute. That one-page permit said all the other requirements of the UDO are still in place. And that's what we're citing them for today. I'm here to tell you that's wrong. What matters here is what the variance granted by the BZA said. And the BZA exempted this sign from the UDO standards except for lighting. And under Indiana law, it's the BZA that does that. It's not a certificate of zoning compliance issued by a development review manager. It's not the development reviews manager's prerogative to superimpose or reimpose UDO development standards that conflict with what the variance said. So stated a different way, the certificate of zoning compliance cannot impose requirements that the BZA did not impose. All right, so let's talk briefly about electronic reader board. Well, let me go back to that. Based on that argument alone, that the variance that was granted by the BZA is what controls here, you have to reverse the notice of violation letter. You don't need to consider any of the rest of this. If the variance controls, not something else, Lamar prevails. But I still want to talk about electronic reader board. The staff said, okay, one of the requirements of the UDO is you can't have an electronic reader board. It's an electronic reader board, so it has to be in violation. But it's not. So an electronic reader board is probably what you see around town from time to time. They're most commonly used by banks or schools. They're a large monument-type sign, and a percentage of that sign, usually 40% or less, is electronic. And you typically see a message scrolling past. Bloomington North plays Bloomington South tonight. Please attend. Whatever civic events, whatever the bank wants to advertise. That's what an electronic reader board is, words that scroll past you as you're trying to drive past. Given the ordinary meaning, this sign, even the digital version, is not an electronic reader board. Let me share with you what else I have in my packet, because I think it's important for you to have perspective. I've talked about lighting requirements. We've not been cited for violating any lighting requirement because there's really no basis to do so. But what I've given you under tab 16 is an evaluation. It's a lighting study conducted of this sign that demonstrates this sign, even in its digital form, complies with your UDO lighting requirement. What I've given you under tab 17 is a summary I put together of the state of Indiana outdoor advertising sign regulations so that you know that the state of Indiana permits digital signs as a matter of right on state and federally regulated roadways. That's what this road is. We have an NDOT permit, and you can have digital as long as you follow their rules, and this sign follows all the NDOT rules. What I've given you under tab 18 are the advantages a digital sign has over a static sign. When you think about this, what's really happened here is Lamar has tried to update this sign so it stays pace with current technology. Digital signs are current technology. I'm reluctant to even call digital new because I don't think it's new. It's been around long enough to be tested. It works. But when you have digital opportunities, you can do things like you see on the first set of photos under tab 18. You can advertise local events that maybe need to be advertised just for a period of days. Typically with one of these static signs, the way it works now is a piece of vinyl has to be printed somewhere. It has to be shipped here. Workers have to climb up on the sign and stretch it out. And it typically stays up for a minimum a period of a month. So you can't use messages quite like this with vinyl. What you see on the next page are special tributes you can do with the digital. And on the last page is probably some of the most important FBI most wanted ads and also all the Amber Alerts. Lamar's part of the Amber Alert program. It's required to be by state law. It is anyway. But if you want those kinds of ads to be effective, they have to go up within hours of the event happening. You can't wait for a piece of vinyl to be printed and then for it to be affixed to the board. What I've given you under tab 19 is when this sign was upgraded and improved, Lamar notified the mayor, asked how can we work with the city of Bloomington, especially maybe perhaps with regard to the arts. The mayor put Lamar in touch with Holly Warren, who works for your art commission, who's already reached out to Lamar and explored opportunities to use the outdoor advertising sign. Finally, what I've given you in tab 20 are letters of support for some Bloomington not-for-profits and business Lamar's already working with that have already been engaged on this sign. Visit Bloomington is one. Hoosier Hills Food Bank has been using the sign, and Bill Brown and Associates, and last but certainly not least, the Greater Bloomington Chamber of Commerce have all made use of advertising space on the sign. It's advantageous for them to use ads on digital signs because they can purchase probably discount blocks. I don't want to speak for Jason on that, but for shorter blocks of time than would normally be required to use a structure like that. But they all asked to have their voice heard and supported our position that the administrator's letter should be reversed and the sign be permitted to remain as is. So I'm happy to field any questions, but I appreciate your time and attention.
Thank you. Okay, so we are to the board for questions, and I'm going to start. Is the agreement that was entered into between the city and what was the former name of the company, Hoosier, is that still in place? Is that still?
Mr. Townsend was referring to is an agreement for Hoosier Advertising Company to remove a particular sign. I think this was at the time that the city was developing the Beeline Trail, and that there would be an agreed-upon additional location. The variance granted Lamar permission to build a sign that would otherwise not be permissible under the UDO. I mean, the existence of the sign, the size of the sign, the fact that the sign was even just going to be there was what the variance granted. And then it specifically called out one particular standard in the UDO. It, of course, did not explicitly exempt all other sign standards when the variance was granted by this body.
Okay. So is this considered, the fact that now it is an electronic sign, is that not considered a new sign? Would there not have needed to be another permit issued for, it's not just like a renovation of a sign, right? Is it considered a new sign?
Yes, a new permit would be required.
Okay.
Well, that's where we disagree.
Oh, excuse me. If you want to go ahead and speak now, then yes. So there was no sign permit. I see that there was an electrical permit.
Correct. So
pulled.
electrical permits are issued by the Monroe County Building Department and are not reviewed or seen at all by City of Bloomington staff.
Okay, so there was no zoning review of this?
Correct.
Okay, so in a standard circumstance, that type of upgrade would be considered a new sign?
Correct. A certificate of zoning compliance is required for that upgrade.
Okay. Did you have a question?
So, I mean, I think that's fundamentally what we're being asked. Does Bloomington want to have canvas signs, or is Bloomington ready for a digital sign? And because the variance was already granted for the sign, so my impression, and this is ultimately my question, is that really what we're deciding here? Is this a digital billboard, period, dot, the fact that it's wrapped with LED lights versus canvas is really the question in front of us. Is that correct?
Yeah, so staff would not characterize it that way. The BZA, we would say in an administrative appeal like this, what you're looking at is whether or not there was a violation, staff's determination that there was a violation of the UDO, of the zoning ordinance, as it stands today, whether or not, in fact, you agree that there was a violation of the Unified Development Ordinance. So we are not offering our personal opinions on the wisdom of billboards or digital billboards versus regular billboards. That is for the elected officials to sort out through the zoning code and the legislative process. We're just figuring out whether or not a violation occurred.
So, and I'll add, so in this case, the notice of violation was issued for this sign being turned into an electronic reader board outside of the parameters that code allows for electronic reader boards. So you're deciding whether or not you agree that that was a violation occurred.
So we're essentially being asked if the definition of electronic reader boards in the UDO is at play here.
Describes this sign, correct. I would say, does that seem right, Mike?
Yeah, that's one of the issues that's been brought up. Of course, you heard Mr. Townsend's presentation. He brought up a number of issues, but that was one of the issues that was presented today.
I would like to elaborate. So if there was an existing billboard in place, if you are changing the sign to be an electronic sign, wouldn't you go have a new permit to do it? Yeah. Wouldn't you apply for a permit to do it? Not only for the electric, but that's a new building permit. You're building a new sign, correct? And when you do that, obviously you would know that that it would be an electronic sign that will be rotating every 8 seconds, or how many seconds?
When we receive permits for other electronic reader board signs, then we make sure that they meet the requirements for electronic reader board signs, including 40% maximum of the face, and that they only change the image every 20 seconds. Okay. So yes, that application, then we would have said, this doesn't meet A and B of electronic reader board requirements, please resubmit. But we didn't receive
what does Lamar have to do to be in compliance?
I'll let Mr. Ricker
So
answer that.
in this case, staff would take the position that they need to return the sign to a static billboard. As you heard Mr. Townsend say, our original position with the April 25th NOV before we had uncovered the 2010 variance was that the sign was now unlawful and it couldn't be located there. Subsequent to that, the determination after we found that variance was that, well, you can have a sign there, but it can't be an electronic reader board sign. It would have to be a static billboard.
So I guess I have a question. Every time Lamar had to change a canvas sign, is that considered, they need to submit a new permit every month?
No, so practice of the department is that they do not do that.
So if they had a crew there switching signs every 30 seconds, that would be fine. But because it's digital, that's the problem.
I believe, yes, because digital, and Mike can correct me here where I'm wrong, or you go ahead. The digital reader board has its own requirements that we need to be able to check those. So if you're opting into that type of sign, we need to be able to make sure that you're meeting those requirements.
And just, you know, hypotheticals are always tricky, but if the face of a sign were changing with that level of frequency, we would want to look at how that implicated the UDO. At that point, other sections may be implicated, but of course that's unrealistic in the context of a static billboard.
I guess I could put a roller on there and it could just roll the canvas. I mean, I'm just, you know, taking the hypo, so thanks.
So my question to the petitioner is, at the time of the BZA variance, 2010, the billboard was a static billboard.
Correct.
Okay. So how would a lack of any information on that variance concerning how it applies to a digital board have any application to what that variance was for? It was a static board, so why would you base your argument, a spurious argument, on the idea that the BZA did not call out specifications for something that it wasn't? You understand? You're saying that there's a lack of specificity in the variance that said, well, you had to abide by lighting standards, which at the time applied to the billboard. Why would the variance go on to list all kinds of things that it should abide by that it's not? It's not a digital board, so why should it have that information in the variance?
I'm going to let Jason wants to comment on that, and I would like to also.
Jason Graham with Lamar Advertising.
You do sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. May continue.
Okay.
Could you speak into the microphone, though?
The main reason would be because digital billboards didn't exist then. So the ability to put a screen up that would have this type of content was not in existence. So Lamar deployed the first digital billboards in 2002. We're actually the largest deployer across the country. So, and when this was originally, in 1998 when Hoosier got the first permit, it would have been permitted as a static. So that's why it was a static back when it was first erected, and that's why they referred to it as a static when they
I want to make sure you understand the question. The question is very specific, which is, why would a variance that concerns a product that's a static billboard necessitate the need to have a specification that you have to also abide by all of these other UDO requirements that don't have anything to do with it? That's your argument, is that you're basing that this should be okay to go out and change the billboard and make it electronic because there's no stipulations in the variance for a static billboard.
Right, well, the stipulations in the variance were required to lighting, and we adhere to those even with the current state of the billboard. So it's very specific that we have to have a certain amount of lucis, 30 lucis to any property line in the lighting. So even with that face, even though we just upgraded the face, we didn't build a new billboard, we still adhere to that lighting requirement. So when they put those in there, that's very specific, you're correct. So we meet that. We also, there's another line in there that says that we have to make sure that we adhere to the glare. So louvers are placed on the lights that are on the board. That keeps the glare from only going towards its intended direction, and also keeps it from 70 degrees from going out. So we did adhere to the lighting.
Does Lamar consider an electronic billboard as identical to a static billboard, or do you consider them different? You sell them differently?
We consider them completely different than a digital reader board.
Okay, so they're completely different.
Yes.
But yet you're using this, I want to understand, you're using the variance for a static to apply to a completely different billboard.
No, I'm using the variance of the being able to operate outside of the UDO. And I also wanted to mention to Mr. Coyne, who asked about the acceptance of digital billboards in Bloomington, that this is, so I own and operate every off-premise sign in Bloomington, and this is the only sign that fits that ability. So there would not be any other digital billboards that could be on any other sign.
No, my
So
final
it's that
question has to
variance
do with
allowed.
was the rotation. So is it still on an 8-second rotation, the current billboard?
Yes.
Why not just change it to 20 seconds to at least come into compliance there?
The NDOT.
I'm sorry?
That adheres to the NDOT standard in the industry standard across the country. That's what the Federal Highway Commission did their study on.
So it doesn't matter what the city wants. It doesn't matter that the city code says 20 seconds to you. It's just whatever the policy is of NDOT. I just want to understand that was your decision, was NDOT says 8 seconds.
I said more than that. NDOT and the Federal Highway Commission did a study, so in order to make sure that sign was safe, we adhered to the studies that were done that said this is what's safe.
So I guess I want to ask a follow-up. Just to be clear, do you view static billboards and the digital billboards as the same thing?
No.
Okay, so the canvas billboard you used to have and this new billboard you currently have are you view them as two different things?
I mean, it's a different product, but they still have changeable copy, and I think that's also what's important to notice here, is that we were allowed to have a sign with changeable copy, and we still have a sign with changeable copy. I mean, you brought up a very good point. If I wanted to go out there and change that billboard every day, I could. So there wasn't really anything that depicted whether or not the changeable copy had to be at a certain interval.
I'm confused about the NDOT standards and the purview of how our zoning works with highway regulation, and there was some mention of this being on federally governed property. So can somebody speak to that, please?
Yeah, so certainly within our corporate boundary, the city is permitted to impose through the city council a zoning ordinance, and that zoning ordinance can regulate signs. So anybody who wants to put up a sign in Bloomington, even if they're compliant with, say, NDOT standards or federal highway standards, if they're going to put up a sign, it also has to be compliant with the local zoning code.
So one does not relieve one, just the NDOT, those standards do not relieve one of having to comply with the local zoning ordinance?
Correct. For example, if somebody put up a sign like this today without a variance from this body for the sign, we would immediately send them an NOV that that's an unlawful sign.
Okay.
And can I add, you may have said this, sorry, that an NDOT permit isn't valid if the sign is not in compliance with local code.
But I just want to follow up again. Am I misreading this original? Because I actually was on the Board of Zoning Appeals at the time that this came forward. I remember this case, and this agreement, though, does it not say that the city specifically reserves the right to enforce any and all city regulations, including but not limited to the provisions of the Unified Development Ordinance concerning lawful non-conforming billboards at such times that this billboard comes under city zoning jurisdiction? Doesn't it say in the future we can regulate this further?
I think you've just read that provision, yes.
Yeah.
So.
Okay.
Well, I also want to add that in the notice of approval on your tab 4, it says, unless otherwise specified by the board at the time of approval, any order variance. And letter A says, in the case of new construction or modifications to an existing structure, 2 years after the date granted by the board, unless a building permit has been obtained in construction, the structures have been commenced. Anyway, it's talking about that you need to, if you do any modifications, you need to go back to the city. Also talks about that in the certificate of zoning compliance, talking about that this permit that was given to this specific BZA approval was tied to the approved revised site plan and elevation submitted on July 12th, 2011. So once you modify something, any building in town, once you modify something, you now have to respond to the current UDO. Go ahead.
Do you mind if I jump in? I think
Sure.
that provision that you specifically called out is simply saying you need to begin, or the variance will have expired if you don't
Okay.
initiate it. Jackie may have a comment as well, but
Appreciate it.
Yes, I think so.
so not to contradict you, but I don't think it's
No,
implicated here.
Okay.
If I may respond to your inquiry, Ms. Burrell, because I think it's an important one. I think that the central issue in this case is this sign, which is still the same structure, still the same skeleton that was built back in 2010 or 11, is it governed by the variance that was issued by this BZA on December 16th, 2010, or do we have to go and comply with all the provisions of the UDO? The variance is what governs. And it says you have to comply with the lighting standard and the lighting standard only. I mean, we haven't complied with this 40% that the casing has to be 40% of the side of the sign since it was built. Nobody from the city has complained about that. I submit to you it's because they don't think it's ever really applied, because the variance didn't require it. It's been that way since day one, since it was built. So to come before you today and say, well, hey, wait a minute, I know what the variance says, but you've got reader board problems now. That's not correct. The reader board component isn't applicable pursuant to the terms of the variance granted by the BZA. So what Lamar did was they took the face of this sign and made a technological upgrade because the technology was available now that wasn't available back when this was built. But there's nothing about the variance that prohibits Lamar from doing a digital conversion without complying with the UDO or going through these other processes.
How do you reconcile that with the plaintiff's own statement that these are two entirely different products?
The product on the head of the sign is different. The pole didn't get changed, that's sunk in the ground and encased in concrete. The framing up at the top of the sign, what we commonly call the head, is still the same. What they did was they took down the vinyl and they affixed the digital. So the pole's still the same, the structure's still the same. What's different is how the sign is displayed. So we've moved from a piece of vinyl that's lighted externally with lights shining on it, and we've replaced it with a product that has internal lighting. Still the same structure, still the same head, different form of technology up at the top. And in all due respect, that's what your variance allowed, as long as Lamar complies with the lighting requirements of the UDO.
Right, and then how do you reconcile, again, the question I brought to you before, which is, at the time, the lighting requirement was for a static billboard, a different product. And now you're asking us to apply a 2010 variance to a static product to a product that you have stated publicly that you changed because of new technology. And now you want us to look at a lack of information about what the requirements are from a 2010 applying to a static board to a new board. How do we do that?
I'm not hiding from that at all. We believe we comply with your UDO requirements for lighting today, even with the digital. We welcome that.
How would you do that?
You go out and you measure the intensity of the light to the property line. That's what the lighting study in my packet addressed. Now, we've never gotten an allegation from the department or anybody at the city that, hey, we're unhappy about the intensity of the lighting of this board. It's never been raised, it's never been brought up. I don't believe that they think it's an issue. But I hit it head on in our packet anyway, that we believe we comply with your current version of the UDO about lighting intensity at the property line.
So the crux of the matter is that that the way that the UDO lays out, this is what's being contended, is that this is a different type of sign. This is not analogous to the sign that was, so that's what we need to decide.
Right, and that's, I'm questioning the petitioner on that very substance, which is, are these different signs? And their admission is they are, and that validates our line of inquiry.
Okay. So are there additional questions at this point? Are we ready for a motion? Or there?
Public.
Oh, I'm sorry, public, sorry. Is there anybody here this evening who would like to speak to this petition? If so, please step to the podium. Or if there's anybody on Zoom who would like to make a comment, this is your opportunity to do so.
We have the same member of the public who was sending some chat, so I think he may want to speak.
Okay.
Are you there?
Yeah, I am here. Ananya Mani again.
Yes, no, this is the same member of public. I do not need to swear you in again.
If you want to, I can.
No, that's fine. You're good.
Okay.
You have up to 5 minutes.
I feel, no, I barely need 30 seconds. So I think if I understood the petitioner's concern, I think that's pretty much valid because the variance was already granted and the company was just taken over. And I think when the structure did not change, the header did not change, I feel the city just going, I think it's more like a power play that just because we have an upper hand on the contracts or the agreements, we would still do whatever. So that's my comment on this.
Thank you.
Thank you.
Is there anyone else who would like to speak to this petition? Okay.
No one else on Zoom.
No one else. So do I go back to the petitioner like at a regular? Yes. So if there's any time remaining, you are more than welcome to utilize that.
No, just to summarize, and I appreciate your questions, I appreciate your patience. I don't think anybody would dispute who does the kind of work I do that it's your variance that controls what happens on this property with regard to this sign. Lamar hasn't built a new pole. It didn't put a new head on the sign. It changed the technology on the top of the sign to technology that's available today that wasn't available back when this was built. So even though this document is 10 or 11 years old, we still have to follow its terms. We don't default to the UDO no matter what the certificate of compliance says. He can't alter the terms of the UDO or the variance. That's not his job. He doesn't have that authority. It's the Board of Zoning Appeals that grants the variance. We have to go back and look at it. It's kind of our Bible from this point forward as to what happens to that sign. So with that in mind, with that understanding, we don't go looking through the UDO to find faults. We just look at this, and if we comply, their notice of violation has to be reversed. Thank you.
Thank you very much.
Ms. Clapper, can I add something for the record, just because I don't think this has been said? The variance we're talking about from 2010 isn't just from sign standards. It specifically says the petitioner is requesting a variance to allow an off-premise sign, parentheses, billboard relocation. So you all, being on the board, know that sometimes we bring forward variances that are more general, like landscaping variances, and then we particularly lay out the details when we're covering more than one, more than a couple development standards. But in this case, the variance very specifically is addressing off-premise signage in the description of what they requested. I think it's fair to say that a concern about lighting for off-premise signs, which we don't normally allow, it would be typical. And so it is the case now and was the case then. Sometimes we call out conditions from the UDO to make sure that those are highlighted for everyone involved in the petition. So to say, in this case, don't forget, we are recommending approval, but lighting will still need to be met. It doesn't mean all of the other requirements don't have to be met. If you approve an architectural standards variance in the downtown, for example, the one we talked about earlier with the windows, if there are particular conditions that we're calling out, in that case, for example, if you wanted to make sure that a certain area had had a certain design or fenestration. That doesn't mean all of the other architectural standards no longer apply. And so I think that that is the way that we have done staff reports in the past and do now. It's more of a call out. It's not excluding all of the other requirements that were in the UDO at that time, which I'm not really sure is actually even super relevant. I think it's clear that based on our definition of electronic reader board, that this new sign meets that definition and doesn't meet the requirements that are required for that type of sign. But I just wanted to kind of lay that out there as well. Thank you.
Thank you. Okay, we're back to the board for action. Do I have a motion, and then we can discuss?
I'll put a motion out there, denial of the appeal, the administrative appeal, AA-31-22.
Okay, do I have a second?
Second.
Okay, any discussion? No? We ready for a vote then?
I guess I'm grappling with sort of the practical realities of this. So our solution is ultimately going to end up being, if we deny the appeal, is we're going to have a big black billboard as our welcome sign to town from the north, from the east and from the north. So as all the football traffic, basketball traffic, and everybody comes into town, they're going to be greeted with the big black sign. So I'm grappling with the practical realities of the decision we're about to make, not to mention some of the, sort of more philanthropic endeavors that come with that particular sign, and the location of it being in a pretty highly trafficked corridor. For emergency notifications, game day changes, things like that. So, part of what I'm grappling with is if there's a way to grant the appeal but ensure it doesn't happen again, and that they abide by 20 seconds, that seems to, otherwise we're going to end up with, an eyesore welcoming people to town, and I don't know that that's particularly what the city council was gunning for with the UDO. I also feel like digital billboards have been around long enough that the UDO would have specifically addressed those versus electronic reader boards, which do seem to me be more like what you see at a school or a bank. So I think the practical realities of what we're contemplating here need to be considered for the city beyond just simply, economic costs to retrofit a board. So, thanks.
Ms. Clapper, if I may just remind everyone, if you are to deny it, there are further steps that will very likely happen. I mean, they won't shut the lights off to this billboard. From my personal experience, just working in planning and dealing with this particular company for the last decade and other things that they have done across the country, they're not going to shutter it. They'll use it as long as they can if other steps that they take mandate that they have to switch it back. They'll either switch it back or they'll be able to keep it. I don't think that I understand what you're saying, but I think the reality is they will continue to use it as is. As they said, they haven't changed it a bit since they heard from us related to, how fast the images are going. None of that has had an effect on it. So until there's a final decision, which you all are not necessarily a final decision board, I don't think that's something to worry about, just as a note.
Well, I do think it's something to worry about. I do worry about the image our city portrays, and that's absolutely, and, hanging a canvas sign over a digital reader or whatever they end up doing, this is the entry point into our city from the north and from the east that the vast majority of basketball fans, football fans, tourist traffic sees. So I mean, I think there's something, and we've got letters from the city of Bloomington, from the Visit Bloomington, from the Chamber, from Habitat, or excuse me, from Hoosier Hills Food Bank, who all use this and leverage the technology. So I do think there is something to be said about the image we portray in our city. So, thanks.
Well, and that goes back to my question, what would it take for them to be in compliance?
Yeah, I think, the answer remains the same as the first time it was asked. They'd have to go back to a static billboard. That's what was approved, that's what the variance approves. That's the way to get into compliance.
So,
I'm sorry, let me ask further. Could a static billboard be could it be the existing billboard without moving images? Could that be considered static?
It's not something that we had considered. No, it couldn't, because it would still be illuminated using an electric light bulb, so it would still be an electronic reader board.
Thank you.
so here's another option. Do they have the option to come back to us and ask for a variance to have a electronic billboard in that location?
I'm sorry, will you repeat that, Ms. Burrell?
Yes, so can they come back with a variance to ask, while they're determining how they can get this in compliance, can they ask for a variance for the BZA to have a electronic billboard in that location?
An electronic billboard that doesn't meet the 40% requirement, like, so multiple variances?
Correct, yeah. So
I'm
then
not
they
sure. I
would be
guess we'd have to
asking for a
discuss that with
variance.
Mr. Rooker.
Yeah, correct.
Yeah, I think that would be permissible. Again, that's not something we talked about, so I'd want to discuss it more.
Sure.
Whether or not that's something that would be possible.
Just to be clear, because our UDO does not have a provision to allow electronic signs at this point.
It has a provision to allow electronic reader boards, not in the situation of a billboard.
Right.
And yeah, that's right. It's the pole sign. That's really an off-premises pole sign like this one is not contemplated by the UDO. As you've heard already, it wasn't contemplated in 2010 either.
So it's unique.
Well, yeah, I mean, the Lamar representative said they've been doing them since 2002. So, I mean, it did exist. It's not something, I mean, I think especially the administration has been open, it's not something that's desired, that we have desired in the past. I don't think that there has ever been an appetite any of the times we've updated the UDO that I've been here to figure out a way to allow them.
Right, that's a separate question. I mean.
Correct.
That's why it's not in the code. Okay, so any further discussions? Okay, so then I think we're ready for, the motion is for denial of the administrative appeal. Can I please have a vote?
Coin,
No.
Ballard,
No.
Burrell,
Yes.
Clapper,
Yes.
Throckmorton.
Yes.
Okay, the appeal is denied. Thank you.
Okay, so it is 8:54. So rules say you can't hear any new petitions past 8:30 and nothing past 9 o'clock. So we have gotten through 3 items, I believe, and have 6 more on the agenda, which feels a little unrealistic at this point. So it's kind of up to you all. Would you like to hear one more? Do you want to start one and set an end time? Or would we like to, hopefully Mike will come back in shortly. I believe the other option is to continue them all to the next hearing. I wanted to ask him, can we set a special date in between? I'm not sure what the rules are on that. Oh, can we ask you? Yeah. Would if they choose not to hear any more or all of the rest, does it go to the next hearing, or do they set a special?
It would go to the next.
It would go to the next hearing. You could set a special session. Yes, but they've been noticed for this meeting, and so then now we're, saying. Right. Yeah, I know.
So it should just be.
Okay. Yeah, so no matter how, sorry.
It has to be a unanimous vote if we want to continue
I don't know. Does the vote
to
have
hear
to be
cases?
unanimous?
If it's suspend the rules.
If they want to continue the petitions to the next hearing, does that have to be? So like, we can just say the meeting is over, because they can't hear anything after 8:30. Okay, I'm sorry, everybody. If the meeting is over, then the meeting is over, because it's past 8:30 and you can't hear new petitions. If you want to hear more petitions, you will have to unanimously vote to amend the rules to continue. And then I would suggest setting an end time or saying how many petitions you're going to hear, so that those who can leave can leave. And then everyone else's petitions would be continued to the next hearing, and I can give the date on that, October 20th.
Okay, what is?
I mean, I would just say that, you know, based on the 3 that we've done, I mean, there seems to be a desire to give each petition, you know, its due course. And if we're going to rush through them, that's not serving the petitioners well. I mean, I would just make that point. I don't have a problem staying,
Right.
but.
Wait.
So
You
long.
know, another month. So I would prefer to stay another hour, another 2 hours, and get as much as we can done in that period.
Some of these have already been continued to no fault of their own, and it really has an impact on those owners. So I would entertain staying to a certain time and getting as much done as we can, whatever would be reasonable if people are open to that. Or committing to hearing X number of more cases, and then those other folks can go home. I mean, that might be more fair. 3 more?
Could I ask how many have already been continued?
One, V-34-22 was continued because we didn't have a quorum, because I had to recuse
Yeah,
myself.
so we had one that was continued. And personally, I have no issues whatsoever with saying, let's hear that case. And then at that time, after we hear that case, see where we stand. And then if we need to suspend the rules further. Because if we decide this next case pretty quickly, we can get through some more.
Just a moment, I'm so sorry,
I don't know if we
guys.
can take them out of order. Yeah?
Okay, thank you. I'm sorry, the rules for Board of Zoning Appeals are different. All meetings, let's see, shall adjourn at 9 PM. No new cases shall be heard after 8:30 PM. Any case remaining shall be rescheduled for hearing at a special meeting to be held within 1 week of this meeting. So we will have to pick a time to meet within the
Okay.
next week.
Okay, so that's the rule.
Correct.
So we don't have discretion.
No, you can suspend the rules. Can they change that rule? I'm sorry, I hate this.
Yeah, I mean, typically any rule can be suspended as long as it's just existing in the Board of Zoning Appeals rules. That's the only place it exists. It could be suspended by unanimous vote and
Okay.
changed. But
Okay.
So I'm so sorry. So you can choose, however, if you want to do 3 more tonight, that's fine, and you would have to suspend the rules to do that. You would also have to suspend the rules in order to continue the other 3 to the October hearing.
Okay, okay. But do we need to hear them in order?
you could do it in one motion or multiple motions, however you want to do it. Is that what you're asking?
Do we have to hear the cases in order that they're presented
No, the agenda can be modified by the board at any time.
at any time? Okay, okay. So I feel like I have to, this is something that I have to, because there's a case here that involves me, so I have to recuse myself from this, although there has to be unanimous vote. But would I recuse myself first?
I just think you have to recuse yourself from the vote.
Yeah,
But
I can
think
recuse myself
you
from
can
the
still
vote.
administer
Okay,
the motion.
Is that okay?
Yeah, and this is, you're not hearing the substance of the petition, you're just voting on whether or not it's going to be heard, so you're good on
So
that.
I'm okay?
Yeah.
Okay. Okay, so I will entertain a motion.
I move we suspend the rule stating we have to hear the last case at 8:30 and hear 3 additional cases, the next 3 cases on the agenda. V32-22, V34-22, and AA 35-22.
How does, do we have a second?
I'll second that.
Okay. Can I have a vote?
Yes.
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 Okay,
Yes.
okay. I would like to request a 5-minute break before we do that. Is that okay? I'm taking a 5-minute break. Okay, I can just do that. We're taking a 5. Reconvene at 6 after 9. Thank.
So
What happens
does
to the
everybody
other
know
side?
their numbers?
She's sick, so. So don't leave yet. We'll make a decision, yeah, when we get back. So we'll make a decision whether we'll hear them at a special session, or if we'll punt to next month. We'll do that right after we get back. Yeah, right after the break. Okay. So just to clarify, we are going to hear 3 more cases, V-32-22, V-34-22, and AA-35-22 this evening. The final 3 cases, we are going to hold a special hearing next Wednesday. What's that date?
Yep. So next Wednesday, the 28th,
The
here in City
28th,
Hall,
at
401 North
5:30.
Morton.
At 5:30 in which room?
Was it 225, Mike? I wrote 255, but I think that's wrong. 225,
Okay.
second floor.
And at that time, we will hear case V-38-22, Bryan Rental Incorporated and First National Realty Partners, V-39-22, Strouser Construction Company Incorporated, and V-41-22, City of Bloomington Redevelopment Commission, Cornerstone. So, so everybody knows. And we will repeat it. We'll repeat which conference room we will be in.
It's going to be upstairs in room 225, which is also called the Allison Conference Room.
The Allison Conference Room.
Five-
At 5:30, so same time that the hearings typically start, and we apologize for any inconvenience, but we're trying our best to accommodate everybody. We just had a very intense docket this week, and so thank you, and our apologies for having to sit so long this evening, and we'll look forward to seeing you all then. Okay, so moving back to our agenda this evening, we are going to hear now V-32-22, Richard Judd. Can we please have a staff report? Actually, we'll have the staff first, and then we'll call you all afterwards. Okay? You're the petitioner. You'll get to come up next.
Also, could I get the page number that this starts on?
Sure.
Page number is 141.
Thank you.
You're welcome. All right. Okay. This is petition V-32-22. The property is located at 508 West 3rd Street. The petitioner, the property is .08 acres. It's zoned R3. Comprehensive plan is mixed urban residential. There's a single-family detached dwelling on the site. You can see it here outlined in red. And surrounding uses are also single-family residential. The petitioner is requesting a variance from the rear setback standards to allow for the construction of stair access to and from the driveway from their single-family home. So you can see here, the petitioner has a deck addition. They are proposing a deck addition to the rear of their house with exterior stair access to the basement and driveway, so kind of from the second floor there. And the rear yard setback requirement in the district is 25 feet. So you can see this is looking at their property. This is facing west, and then the stairs would be here on the north end of the house. So you can see that they derive access to the basement garage area from under the addition. So this, you can probably kind of tell, is an addition that was put on, I believe, in around 2015 when a previous variance was granted to allow for some decking and stairs, but in a slightly different location than what they're requesting tonight. The currently existing deck is highlighted here. And then the rest of the deck that is shown is what was part of the 2015 petition but was not built. The outline portion around the existing deck labeled landing and down is proposed. So some of this decking here with stairs is what was part of the original petition. So the stairs leading to the deck would be facing and going down to the east as opposed to coming off the north end of the structure. So the proposed stairs are 3 feet wide, leaving a 2-foot side yard setback. And the landing is also 3 by 8, and that leaves an 8-foot rear yard setback. So these are our general criteria for development standards. Excuse me. The department proposes that no injury to public health, safety, morals, and general welfare is found. A deck and stair are the deck and stair that are proposed are proportionate to the addition and house on the site. No adverse impact is expected on adjacent property. The petitioner has communicated with the Historic Preservation Commission and of course mailed notice for this meeting, and no concerns have been raised. However, no practical difficulty is found. When the addition was done 7 years ago, space for outside stairwell or inside stairwell could have been accommodated and wasn't, and now the petitioner is coming back. The property owner is coming back to request variance. As the packet said, smaller addition could have been built, and the use of the property will continue, obviously, as a single-family dwelling, even if the variance isn't granted. Based on it being difficult to find a proposed finding for the practical difficulty portion of the findings, the department is recommending denial of V2232. I can answer any questions.
Thank you. Petitioner, or petitioners, yes. Okay, please step to.
My wife's going to hand you a bullet point, and I'll.
Okay, so if you could please step to the podium and state your name.
Richard, last name Judd, J-U-D-D, and.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you have up to 20 minutes to make your case.
Thank you.
Thank you.
I'll make it quicker since it's been a long evening. Anyway, Linda and I just moved from out west, California, if you get reality. My son moved here, and his wife went to IU, and we followed. Okay, we got to an age where we want to be with our son. We bought this little house at 508 3rd Street, moved in on December 1 of 2021, so very recent. Okay, December was off and on, but January got very wild weather, as saw through wherever. Anyway, with the alarms and so forth that's going on, the house has a basement underneath it, and if she'll put that picture up, a basement underneath. When they remodeled the house in 2015, and that's what that picture was from, they actually did not put a basement in the house like they originally probably was designed, or we're going to put the stairs, the next picture, the other picture, the drawing. Oh. I'm sorry. That's okay. That one right here. I'm going to move over here, hopefully. This was done by her, and I don't know if you can see.
Oh, Mr. Judd, will you stay by the mic so the people on the line can see you?
Yeah, down a little further.
Sorry. Okay, let me see. How about this one?
No. Yeah, you can see right where I got the little plot right in there. That's where it was to be announced, TBA. That little circle area. Anyway, they were going to put they never did it. They never put a way to get into the basement. They never built the stairs down, which they had planned to do. I have asked for, since we moved in, we got, how would I put it? We got a senior wake-up call, let me put it that way, in January. All of a sudden, we had no choice but to run down that alley, basically, to get underneath the basement, if we were going to do that. Now, I even went out today and measured that, and I've got 154 feet from the front door to the basement entrance, outside, out around the alley. Okay, if I build, as I proposed, that deck that goes down there, I figure it's about 15 feet from my kitchen area, which is a kitchen there, that'll put me into the basement. Okay, so that, it would be quite a good thing. Excuse me here, I'll get my notes. My wife helps me with the notes here. So I brought Mark Apple with me. He's a neighbor that actually has lived on that side for a lot of years. Yeah, and so he was here in the 2015 hearing and testified, in 2015, and it was recorded. And so he's come to testify again because he realizes the idea of that alley is so steep, especially when there's ice and so forth there. It's not a place to go down there in January or ever. So anyway, they talked about the practical difficulty. That would be one, running down through there, have to go around that carport area and there's doors where you'd have to go into the basement. Got a nice big basement, it's all set down there. So I am basically requesting, that we be approved. Now, I should say I'm a disabled veteran out of Vietnam. So we come here, my wife and I, what she calls the home before the home. Sorry.
Can I speak?
I'll let her talk.
Yes.
State your name.
Linda Judd.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Yes. I wanted to say for my husband and I that when we came to Bloomington, fell in love with Bloomington, and I fell in love with this house and decided this would be the home before we get sent to the home. And when I heard the tornado warnings and all that, and I started watching the news and hearing be weather aware, and realized that the best way to be weather aware was to be in the basement when there was a tornado watch here. And we would not be able to get there too easily, as we had to go around and, like, again, if the weather's bad, icy, snow, there's other cars coming up the alley, it would be very difficult. So I would also say, as a senior, that I want to be around in this home before I go to the home, and I think this will help us stay there a lot longer if we can have a safe place in the basement during a possible tornado. And I'd like to have our neighbor speak. Yes.
Actually, your neighbor will be able to speak as part of the public shortly.
Oh, okay, so we'll call you at the public.
Okay, thanks. Thank you both. Okay, so we are to the board for questions of the petitioner and staff. I'd like to ask the staff, I just want to make sure I understand. So there's a side setback variance issue and a rear yard with the way that the stair is proposed now? Because of the unusual shape of the lot?
Yes, hold on. I think it's just rear. I'm sorry, I'm pretty sure it's just rear. Because I'll have to look, but there's an exception where stairs can encroach into a side yard setback.
Okay, but
So I believe it's just the rear that we're looking at now, which is the 8 feet from the back.
Okay, but the,
Yeah, the exception covers the setback, so it can be that close to the setback for the side.
for the side, but
Correct.
not for the rear?
Correct.
Yeah?
Yes.
Okay.
Okay. So basically, in 2015, they got a variance to allow steps, I'm sorry, not these, but the previous property owner
Yeah.
got a variance for this design here, and it did show stairs in this location, which when you look here at the house, it's like in this rough area here. So to be coming off the house and going east. So, they made an argument for them, got that, that's fine. And it wasn't, I'm not even sure, I'm sorry.
This
Sure,
stairs-
would you like to answer?
Excuse me.
Would you like to clarify? Yeah.
I'm sorry. I started this in January. Different things have been happening along the way, but I finally got here at the second time. Anyway, the stairs originally were designed.
You're gonna have to stay at the microphone so we can hear you. Yeah, sorry.
The stairs originally were designed to go across the back of the house and wrap around and come all the way over and come over in the other area over in here, okay? They never built the ones to the left of that up there. So I had Chris Valiant, he's the one that's gonna be building, design it, or come out and look at it. Because the garage is there, that staircase doesn't work. So I've had to really come up with pushing the landing back 3 feet so there's enough room for a landing to come down this way along the side of the house. I'm not gonna build any of the other ones. They took areas that were gonna be for the other
anyway, they took those other areas and turned them into a little room that we use.
Okay.
And there's no room, it's all brand new inside, so and they put ducting underneath. So to go through that or is prohibited, I mean, it's undoable, quite frankly.
So the way that the stair was drawn initially would have accessed the yard. It will not access, you're trying to access the basement as directly as possible.
Yeah.
Okay.
Yeah.
Okay.
Yeah, I thought they were going to put, according to that drawing in 2015, I can't find any building records because I've tried to do that. The only thing I did is thanks to Karina she found this report by Misha back in 2015, you know, and that's where that plan came from. But they modified the plan, but I've never found any building permits, anything from that point on.
Okay,
So
thank
I'm
you.
being quiet, okay?
Great. Any other questions? Okay, so then we are to the public. Would anybody here like to speak to this petition, please? If you could step to the podium and state your name.
My name's Mark Apple.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you have up to 5 minutes.
Okay. Well, I'm their next door neighbor, and this is my property is the one that's near to, and it's not near enough to bother me at all. I have a big back property. I want my neighbors to have a good life and a good house, and it's really hard on them to come all the way out of the front and go all the way back down into the basement. That's ludicrous, really. And I want them to be, I've been in the house, they'd have to destroy their house almost to make an access from the house down to the basement. It would really just ruin it. And there's no problem at all with me or with any of the other neighbors. We just, and it's just the back, and it's just a little bit, you know, so we're not really concerned at all about it at all. We just want everybody to be happy and be able to get around safely. That's the safe is the big thing, you know. Once you get old, it's a little bit more of a consideration. Thank you very much for your time.
Thank you. Okay, anyone else from the public who would like to speak to this petition? Is there anybody on Zoom?
There's a number of people that chatted, so I don't know if there's anything there.
Yep.
Thank you. I think those were all left over from the previous, trying to find out what cases we were doing. Thank you. Don't see anyone with any hands up or messages on Zoom.
So then we are back to the petitioners. If the petitioners would like to say if you would like to say anything further at this point, it's your opportunity.
No, I would surely appreciate having access to the garage, and I've had somebody that laid that out and it will build it. I'm just waiting to get final approval, you know, to do that. So hopefully I made the case that we need that. You know, it's really a safety hazard for us to, you know, keep going down the alley. So I guess that.
Thank you. Thank you. Okay, I'm back to the board for action. Just a quick question, Jackie. So we're talking about a variance of 2 feet into the sides, into the rear setback, because it's a 10 foot.
It's a 25-foot
Really?
in the R3. 25-foot rear setback? Yes.
Okay.
Yeah.
It's R3.
It's R3.
R3.
So that means there would still be 23 feet?
Sorry, say that again.
So that means if this encroached 2 feet, public
Then there would
ground,
still be
there would
23
be
feet.
23 feet.
Right.
Okay, got
So
it.
you envision like a typical backyard, house in the front, yard in the back. I mean, this one is a little borderline for us, if I'm being honest. Because of the shape of the parcel, I think we struggled a little bit because the addition is kind of so new, and they came to the board in 2015 with like this holistic plan of this is where we're gonna put the stairs, and this is why we need the house to be this big, and then they kind of didn't complete that thought, and now want to add on even more to the north side, where there had been discussion about how far that was. So us knowing that there is another option that doesn't encroach as much into the rear property, because we've seen it, and they got approval for it, to have the stairs go east-west further south, is kind of hard for us to recommend approval. We do understand that it's a little borderline. I mean, the property is definitely oddly shaped, and so if you were inclined to go that way, we do think you could pretty easily craft probably a third finding, kind of relying on the shape of the property and that there isn't really a traditional backyard here. So, either set of stairs would have its own issues. It's just that the one's kind of already been litigated by this board, so we felt more comfortable trying to steer them that way. And then but they chose to come forward with this design.
Okay, thank you for the background.
I'll make a motion to approve variance V-32-22 with the additional findings of the potential danger to the occupants for not being able to reach a safe area for things like tornadoes, and due to the awkward layout of the property line.
Could I fine tune that a
You
little
sure
bit?
can, sure.
Okay, just to, because a peculiar condition of the site is that the previous development and how the garage is located, and that the new stair will provide a direct access to the garage, allowing for a safer condition, and that we have an unusual site lot configuration, which is not typical and doesn't really allow other configurations in terms of being able to access the garage, because it's right up on the alley or the other street, right? Okay. I need a second.
I'll second that.
Okay. Any further discussion? We are ready for a vote.
Yes.
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 Okay. The variance is granted. Thank you. Good luck to you all. Be safe. Okay. That's the plan. Have a good evening. We are on to our next case, and I let the record show that I am recusing myself. That is V-34-22, Adam Jackson, Caritas, Indiana, LLC.
What page number is that on?
That is on page 151.
151?
Correct.
Thank you. Let the record show that Barry Clapper has recused herself from this petition, and that I will be administering the board on this. And if you would, please give us a staff report on B-34-22.
Thank you. This is a request for a property at 1420 West Kirkwood Avenue. The petitioners, Caritas, are requesting a variance from the buffer yard standards in order to allow for the construction of a 16-unit multifamily building on this property that is located in the residential high-density multifamily zoning district. So this is on the west end of Kirkwood Avenue. The property currently has a house and garage on it. The petitioner is proposing to tear down all of the existing structures and construct a new building. This would be a multifamily building. It meets all of the height standards and other standards for the site. However, the property itself is only about 50 feet wide. And this lot has corners. On the west side, there is Hopewell Street, and on the south side is Kirkwood Avenue. Both of those have a 15-foot setback requirement. And on the east side of this property, there is a contractor's yard on the adjacent property. That presence adds a type 3 buffer yard onto the side yard setback along that side. So the base setback in this district is 10 feet, and that 20-foot buffer yard adds basically a 30-foot setback from the east property line. So when you combine that 30-foot with the 15-foot setback from the front, that basically takes 45 feet out of the 50-foot wide lot out of play and only leaves you a 5-foot buildable area. And so the petitioners are requesting a variance in order to allow for the new building to be constructed. The building is shown to be 10 feet from the east property line, which is the base setback of the district, but they are requesting a variance from the additional 20-foot setback that is required as part of the buffer yard. The buffer yard does carry with it a landscaping requirement for trees. The site would be meeting that requirement. They are only requesting a variance from the additional 20-foot setback. As I mentioned, the narrow lot size certainly is a peculiar condition about this site that does not allow for it to be used without the granting of a variance, which is certainly one of the fundamental principles of variances, is to grant relief from the terms of the zoning code. So we are recommending approval of this request with just the 3 conditions that are listed in the staff report, and I'm happy to answer any questions.
Thank you. Is the petitioner or a representative of the petitioner? Oh, thank you. Are you the petitioner?
No.
You're a representative of the petitioner? Would you
Yes.
please state your name, and then I will swear you in, and then we'll have your comments.
Jane York with Spring Point Architects.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You have 20 minutes, and the amount of time you do not use now, you will have available to you after all comments.
Okay, thank you. I believe we also have the owner, Adam Jackson of Caritas on Zoom as well. Want to thank Eric Grulick for the staff report, and just wanted to make a clarification that the petitioner's statement did state that a level 2 15-foot buffer yard was required. We have since found out that a level 3 20-foot buffer yard is required. The variance is for the additional 20 feet, although the project can accommodate the buffer yard landscape requirements within the 10-foot setback with the fencing option for level 3. We are here to answer any questions you may have.
Thank you. At this time, we come back to the board. Any questions that you would have of either the staff or the petitioner, we will do so now, please. Any questions? Thank you. With that, is there anyone in the public here who would like to speak to this petition? Seeing none, is there anyone on Zoom?
No, let's see. We do have one member of the public. Just a second.
Did you say we do have one?
We do have one. Just a
Okay.
sec. Can you unmute?
Yes, can you hear me?
Yes, thank you. I will ask your name, and then I'll ask you to wait for me to swear you in. Your name, please?
My name is Kimberly Stanley.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You have up to 5 minutes.
All right, well, I received a few months ago, actually, I believe this petition was supposed to be presented last month. Me and several of my neighbors were coming in, were going to be present to come to lodge our concerns about having this apartment, the 16-unit apartment building being built so close to our property, especially in the area that it is in. The gentleman mentioned that it's next to Kleindorfer's and a construction place, but he failed to mention that it's next to also a church. Our concerns have to do with parking. Our concerns have to do with traffic. Our concerns have to do with noise level. Our concerns have to do with there's a barrier that separates our property from this proposed building, and thus traffic patterns. Our concerns also have to do with noise. Also, the current residents who are in this area is also you have a lot of mobile homes in this area. How much disruption would that cause for them? They're under the impression that they will lose their homes, and that it's not just the 16 unit that's going to be built, but additional units are going to be built, which again, I have not heard that mentioned in the petition at all. So these are questions that I have, and also concerns. Again, my fellow neighbors could not stay because per your rules, this is over at 9 o'clock. And so again, the community comments that you would have gotten, you will not be able to have because you, of course, decided to make this exception when you didn't, and we weren't notified last time that this was not going to be petitioned. So those are my concerns. And again, I can only speak for myself, but I do know my fellow neighbors are not for this. Thank you.
Thank you. Do we see anyone else online who would like to make comments?
Yes, there's one more.
Thank you.
Oh, wait, I think it's you said Adam Jackson? Yeah, so he's the owner, so he will be able to speak at that time. Yeah.
Very good. So you're finding no other?
No other hands have been raised.
Okay, at this time then, we'll return to the petitioner, and I believe you have about a little more than 19 minutes left to address any further concerns, both you or the other participant on the petitioner side can speak at this time.
You should be unmuted.
If he would like to speak, I just need to swear him in. If you'll state your name, please.
My name's Adam Jackson.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, and the two of you together combined have 19 minutes left.
Thanks. I'll try to keep this quick. I just want to respond to the person who just spoke and let them try to allay their concerns a little bit. One, I've actually met with Pastor Jonathan from that church, and he is happy with what we've been doing so far. Me and my business partner also own the mobile home park across the street, and at least they've expressed to me that they were very happy with how we're kind of helping the area, I won't say clean up, but just helping it become a little bit more responsive or responsible. We have a lot of interactions with the police, not because of anyone on our property, but because of stuff that happens around there. There's a homeless encampment inside a creek that's right next to us on the church side. And we're trying to build a better community. We cater to a second chance community, people who've gone through like Wheeler Ministry or Volunteers of America. The people who live there, most of them do not have vehicles. This is all going to be housing that's priced at the BHA level pricing, and typically people there don't have vehicles. I don't think that there's going to be that much of a foot traffic there. And the mobile people in the mobile home park are looking forward. They get first dibs to move into the new apartments if they can be built, and they're actually looking forward to moving outside of the mobile homes into the apartments. Thank you.
Also, I'm not sure you want to be displaying comments. That's outside of public comment, is it not?
Yeah.
Okay, thank you. At this time, do you have anything further to add with your remaining time, which is 17 and a half minutes?
I'd just like to add that it's my understanding, and Eric can maybe comment that, I believe the whole site plan meets the standards of the UDO, as does the use in this neighborhood, and that's all I'd like to say.
Thank you. So with that, we'll come back to the board entertaining a motion. A motion will be followed by discussion. Do I have a motion?
I have a motion to approve V-34-22.
I think there were 3 items that you have to also note if you're going
Also have to work on the 3 items.
I'm sorry?
Have to work on the 3 proposed findings?
No, you're seeking, but
Yes,
please state
sorry.
the 3 as well.
Yes. As recommended by staff, number 1, site plan approval is required prior to issuance of a grading permit. Number 2, this approval is for the submitted site plan only. Number 3, no variances from building architecture standards are approved with this petition.
I have a motion in front of us. Do I have a second? I have a motion and a second. Is there any further discussion? Seeing none, let's call the vote.
Coyne?
Yes.
Ballard?
Yes.
Throckmorton?
Yes.
Burrell?
Yes.
The motion passes. V-34-22 is approved. And at this point, let the record reflect that Barry Klemper is coming back in to join the next case. We'll try to be faster next time.
Okay, let the record reflect that Barry Clapper has rejoined the board. And we are to our last case of the evening, AA-35-22, Chris Bamba. Please have staff report.
Page number, please.
Oh, sorry.
Sorry.
I also need one of our meeting hosts to let me co-host the meeting because I had to drop and rejoin. Sorry.
Thank you.
She dropped off the Zoom or something?
That's why she had to go.
All right, thank you for bearing with me. My name is Liz Carter. I'm the Senior Zoning Compliance Planner for the Planning and Transportation Department. This is an administrative appeal, AA 3522, from a notice of violation for failure to comply with development standards. The location of the property is just southeast of the city center. You can see on the map to your right that this is located on South Henderson Street between East University and East First Street. The property has an area of 0.11 acres. It's zoned residential small lot, or R3. For the R3 lot, the maximum the maximum impervious surface coverage is 45%. An NOV warning was issued to the property on May 13th, 2022 for failure to comply with development standards, specifically the impervious surface coverage maximum. The compliance date that was listed on the NOV warning was May 27th. Staff did not observe any change at the property, and staff was also not contacted by the property owner. The notice did go out to the tenant and to the property owner. So a couple weeks later, staff issued a notice of violation on June 23rd, 2022. The compliance date for that notice of violation was July 7th. Before that, on June 28th, Mr. Bamba contacted staff and indicated that he wished to appeal. The table shown on the screen is from the R3 zoning district standards. In the highlighted portion, I'm sorry if it's kind of hard to see it, states that the maximum impervious surface coverage in the R3 district is 45%. On the screen now is the definition of impervious surface. So the first couple are fairly obvious: buildings, accessory buildings, porches, stairways. The fourth one is the one that matters here: parking areas and driveways, regardless of surfacing materials, unless an alternative pervious paving system is approved by the Planning and Transportation Director. So those are items that would count as impervious surface. On your screen is a visual that was also included in your packet. So the way that I calculated impervious surface here is we took an aerial. I calculated this in ArcGIS. Unfortunately, it's hard to visualize something in ArcGIS. All the different colors and separations and call-out boxes don't show up on that. So I measured in ArcGIS. I drew this up in a PDF editor. And as you can see, the parking area, when conservatively measured, came out at 909 square feet. I do say conservatively because you can see that to the south of the parking area, there's sort of a no man's land where we kind of have maybe dirt, maybe gravel connecting to the parking lot to the south. I didn't count that just to be conservative. The driveway running alongside the house measured out at 622 square feet. And then the building and porch and a corner of the building that has been blocked off, which we'll see here in a later photo, came out at 1,134 square feet. When we take all of that square footage, add it up together, we divide it by the square footage for the total lot, we get an impervious surface coverage of 55.6%, which is, of course, over 45%. This is an image from Google Street View. It's from 2014. It shows the driveway running along the side of the house. It shows the back parking pad. And in this photo, you can see the front porch, and then you can see that to the left of the porch, there's been some additional impervious surface added there as well. So this is the original building permit that was approved for this house in 2013. This is the CZC on the left-hand side. As you can see, the first condition of the CZC was to remind the applicant that 45% impervious surface coverage was the maximum for this project. On the right-hand side, you can see the site plan that accompanied the building permit plans. A couple things to note: the parking area, as shown on this site plan, is smaller than the parking that we see on site from the aerials earlier. Additionally, the driveway has some separation from the house. In this site plan, it does not have separation from the house now. So those are just a couple things that changed. Finally, the back deck headed into the parking area. You can see that there's clear distinction here. There's a very small deck, there's a little pathway, and then the small parking pad. It's all become kind of muddled with impervious surface as it looks today. So finally, the maximum impervious surface coverage in the R3 zoning district is 45%. The property, when measured conservatively through aerials, came in at roughly 56%, and the conclusion of the notice of violation is that the property is over impervious surface coverage. Thank you.
Thank you. Is the petitioner here? If you could state your name, please.
Chris Bamba.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you have up to 20 minutes.
Quick little history on this. I bought this property, the lot, in 2013. I personally did submit that site plan that was registered up there. Once we received the permit, I did turn it over to a builder who actually went through the building process, working with the building permit and building the property. We've got our occupancy. I'm assuming it's 2014 because the assessment was done in 15, and it's been a rental property ever since. We've had no issues with it ever since. My assumption was we've been in compliance the whole time. There was no ill intent or ill will to purposely change the layout or cover more impervious space. I spoke with the builder once I got the notice of violation that there was an expanded parking area. I went to the site. Nothing had changed since the building was originally built 6 or 7 years ago. The builder mentioned when we talked, he doesn't remember why we didn't put concrete in the back, that was supposed to be a concrete parking area, why we left it gravel. We had no thought there. Along the side of the house, they mentioned that the driveway is a little bit closer to the house than it should have been on the site plan. Could I have that picture of the house from the front, the first one? He did recall when we were working on the driveway, the property line in this area with our survey, we're not sure if we're a foot short, a foot long. There was 2 markers that were in the ground. But if the driveway, he did remember the driveway was moved closer to the house, and the reason being he spoke with the building inspector. You see the telephone pole there? If the driveway was pushed over 2 feet further, that would have been a safety hazard for anyone pulling in and out of the property. The little spot to the front left of the house, that was done there because the sewer line, the height of the sewer line below grade, you need to have it so far below the ground to make sure it doesn't freeze. So they had to build a little wall and put pieces there to it. Again, one of my things in my statement is this could be over the impervious space. It could be less the impervious space. One of the things on the GIS website, and I've been told many times, is you can't use a GIS site for specific measuring. We're talking about a very small area. I'm still perplexed as to how somebody, per the notice of violation, someone complained about this. I'm not sure how someone could have walked by and said, hey, this is maybe 10% over the impervious space. We haven't had any issues with parking. It hasn't caused any harm to any of the neighbors. And so I'm just asking you to kind of, I guess, with my appeal to let this go. I mean, I guess the options are for me is to put a concrete pad in the back and, rip out some gravel. But other than that, to really specify what the exact square footage is, the cost of the city to go do survey or me to go do survey for this small amount of spot on this small lot is, I think kind of a waste. And I made sure the house, when we built it, that kind of fit with the neighborhood when we did that. So thank you, and I can answer any questions.
Thank you. We're to the board for questions of the petitioner or staff. I have a question just off the bat. Is gravel allowed? Was it allowed in 2014 as a?
Gravel is allowed for parking if it's edged.
In what?
If it has an edging around it, some sort of like containment, so that it's not just going out into the yard or the right away. I can check the 2013 UDO, but I'm pretty sure that that's the same. Meaning, I'll double check, but possibly part of the reason why the site plan indicated something else was to address an issue related to that. And additionally, whether or not it was on the site plan or the CZC is kind of irrelevant. The current code is 45% and it doesn't meet, and we got a complaint. So it needs to be corrected.
Okay. Any other questions?
I just have one for the petitioner. Just to be clear, like, you've done nothing since 2013 or 14 to the back to extend this, or your tenants haven't, or anything like that?
I've done nothing to it. When I got, the warning letters went to the property management company. I never got those forwarded to me. The NOV was kind of more important, so that got forwarded to me pretty quick. I went out that day and looked, said, okay, who's expanded the parking area? Seeing nothing, I asked the property management company, has there been any work there done to expand it? There was not. And the tenants at that time were asked, and there was not.
Is it possible that, like, the gravel is just getting thrown around? I mean, it's gravel, that it's like moving?
I don't know, and that's what I'm saying. I don't know why the concrete parking pad was not put down in the back and it was left as gravel. I did try to look in the UDO for 13 to see if gravel was an impervious, allowable impervious space. Also the back, there's some area that you mentioned south of the building. The neighbors next door, which I own the house next door, have been parking over towards onto this property, which has kind of caused it to look bigger than it is. And we've told them, no, you can't be parking over there. But no, there was no ill intent here. The house, it was built, it's been approved, it's been through 2 hand cycles and approved. So I was kind of a little bit shocked when I got the NOV.
So is it possible that the gravel has been spread because of the cars driving over?
It could have been.
There was no containment to the gravel?
Yeah, the gravel could have been. The gravel's a little bit higher in the spot. The GIS site, there are bushes there that hold it. It could have expanded. But like I said, using the GIS site, if you go to the GIS site, there's a disclaimer not to use that as a measuring tool. And it could be over, I could be under. I mean, we're talking a small amount of area.
So I have a question for staff. So what is the solution here?
I'm sorry, what's the solution?
Yeah.
The solution would be to come under 45% impervious surface. So I think that, as he maybe indicated, that if the gravel was reined in and edged or some other parking surface was found, we might be under 45%.
So are we talking about building an edge around the gravel and then removing the excess? Is that?
Yeah, I mean, I think you guys don't see, all the NOVs we write and stuff, right? So we write often to property owners. A lot of times it's property management companies because they're not on site every day. The renters are parking, they're kind of spreading out and saying, hey, we need you to pull this back in. And then they do, they pull it back in. They plant sod or put up edging. I mean, there are lots of things that we see done, railroad ties or whatever, indicating to a renter, this is where the parking is allowed, and kind of keeping that. That's fairly common for us. We see that. So, there's no, Mr. Bama says there's no ill intent. That's fine. We aren't saying that there is, and we don't really care whether or not there is. We got a complaint that they're over impervious surface. We checked it out. It appears to us that they are. They've presented no information to us to indicate that our estimates are incorrect. And so we need them to bring it within the 45%, just like any other property in this district if we got a complaint that they were over as well. So yeah, the remedy is to scrape up some of that gravel, put it onto the larger gravel area, put in some edging, potentially some grass seed, before winter, and have it be clear where the tenants can park, so that they're not just over time expanding and turning the entire backyard into gravel, which is something that we hear about frequently, historically, that in neighborhoods where the houses are built traditionally single family, people often worry about that happening to the backyards, and this particular backyard is largely parking, so that's probably where they'll address the issue.
The petitioner noted that it could be over or may not be over. So my question, this goes to staff, actually. My question is, if we were to deny the administrative appeal, and you were to go out and physically do a measurement, because that seems to be the question. It hasn't been physically measured, it's been looked at in different ways. And you find that the property's well within compliance. There would be nothing further, there'd be no fines or anything, right?
Correct.
Okay, so if it's under, the 45% or under, then it's fine. We just don't know because no one's gone on site and actually physically measured it.
Sure, we're pretty sure it's over, but yes.
I understand, you're pretty sure, but
yeah.
we don't know for sure.
We don't have a survey.
Yeah.
So we say, this site needs to be brought into 45% compliance. If the property owner says, oh, it already is, then we say, oh, great. And then
Right,
that's
I just want to make it clear, though, on the record, that if we do deny it, and then it comes to be that it is in compliance, there'll be no fines. I just wanted to be clear. Thank you.
You're welcome.
Okay. So we are to the public for comment. See no one here?
I think there's some people left on Zoom.
Okay, okay.
John Torok, and I'm going to ask you to unmute.
And if I could please ask you to state your name?
John Tork.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You have up to 5 minutes to speak.
Yeah, so I was the one who made the original complaint, and it started a couple years ago when the Plex discussion happened, and that's really when I learned what the rules were for an impervious service, et cetera. And so this property, this is a relatively new property in our neighborhood, and with the Plex discussions that were going on, and the fears of the inner neighborhoods of what could happen, I brought up this property as an example. And I'll say that the estimate that was given is pretty conservative in that the parking area is pretty, it goes through. I've seen the cars driving back and forth and parking on that area between the two properties that are owned by Chris Bamba there frequently in the past. And so it sounds like if that was contained, I was put down, et cetera, I would be happy with that at least. Thanks.
Thank you. Is there anyone else who would like to speak to this petition? Nope. Okay. So we are back to the petitioner for further comment.
As far as people driving from parking spot to parking spot, that may be also why the area in between the two houses is covered. I have no problem putting up a barrier there, so they cannot do that. Again, I don't know what the 2013 code said. How that gravel is set, it is raised a little bit. So I guess my question back probably would be the staff. If I had to go back and put a barrier around it, would I have to even shrink it more? Because the barrier now is also an impervious surface, and you'd probably need blocks. So we're shrinking the parking area. I mean, the little front on the side, I can kick out some gravel, put some mud, and put some grass or planting there along the side of the house. It's just a small area that has gravel. We can take that out and put, river rock in. If you put dirt or anything, it's just all going to run out because it's on the shady side of the house and needs to have some sort of stone in it. But, I mean, other than the only way to find if this is in compliance is to go measure it. I mean, the south side of the property, whereas there is mud, we can do something to make sure people aren't driving back and forth. But thank you very much for your time.
Thank you. So we are back to the board for action. Do I have a motion?
I'll go ahead and move to denial of administrative appeal AA-35-22.
Do I have a second?
Yeah, I'll second that.
Any discussion?
Well, looking on the GIS, I see why the possible complaint came from. As you can see, there's a huge parking lot connected between 3 houses. I know they are not connected, but it looks that way. And I'm sure people violate and just go through them like it's a street because it just feels like you can go through in the back. And that's possibly what caused the complaint. So I understand that. Do you see what I'm saying?
Yeah, yeah. So can I ask just a question at this point? We have a second. We have a motion up.
Sure.
So the adjacent properties, are they governed by the same, even though?
They all belong to him.
Oh, they all belong to Mr. Bamba? Okay, okay. So they were all developed at different times, though. So does that, in terms of compliance, does that, of the other properties?
For us, based on the size of our enforcement team, which is Ms. Carter and one other person, Ms. Burrell behind me, this type of issue we're addressing on a complaint basis or if it's causing some sort of issue. So we'll deal with this address and that's it. Yeah.
Okay, just curious.
Yeah.
Okay. Great. We ready for a vote? Okay.
Burrell,
Yes.
Point,
Yes.
Ballard,
Yes.
Clapper,
Yes.
Throckmorton.
Yes.
Okay, so the petition is denied or the administrative appeal is denied. Thank you very much. We are adjourned.